Good morning, everyone. The time is 9 o'clock. My name is Christian Waugh, and I hereby call this Citrus County Code Compliance hearing to order. We follow an agenda at these hearings. You may have a copy with you. The first item on the agenda is the call to order. We just did that. The second item on the agenda is the pledge to the flag, so I'd like to ask if you join me in standing for the pledge. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you all.
Good morning.
Good morning.
If any person decides to appeal any decision made by the Code Compliance Special Master with respect to any matter considered at this public hearing, he or she will need to ensure that a verbatim record of the proceedings is made, which record shall include the testimony and evidence upon which the appeal is to be based.
Okay. Thank you. And the next item on the agenda is approving the minutes from the Wednesday, October 18th, 2023 hearing. We don't have them yet. Okay. Well, in that case, I will table that to the next hearing, unless there are any objections to doing so. Okay, I don't hear any. We'll table that to the December hearing. Staff update?
Oh, sorry. Staff update, abated and continued cases are listed up front.
Okay. Before we get to your cases, I have a short statement that I'm going to read. It'll apply to all cases, so I just ask for your attention as I go ahead and read it. Good morning again. My name is Christian Waugh, and I'm a licensed Florida attorney acting as what is called a special master. That's a fancy title created by the law, but what it means is that Citrus County has hired me to preside over your hearing. What I'm going to tell you during this opening statement applies to each of your hearings, so I appreciate your attention. When your case is called, please come forward and you will be placed under oath. If you are appearing at a hearing like this for the first time, I will state the alleged violation and allow the county to present its case. After the county, you will have an opportunity to cross-examine any of the county's witnesses, and then you will have an opportunity to present your case. So first, the county, I don't even understand what the case is until the county presents it. So it's important that I hear what they have to say first, and then I definitely want to hear what you have to say. But that will be your opportunity to present evidence and make legal argument. It is important that you take your time during the process because it is likely going to be your only chance to make your case. At any time during the hearing, I may have questions of the parties, witnesses, or staff. Before issuing a ruling, I will ask if there are any members of the public who wish to speak. And if there are, such members of the public will have one opportunity to speak per case. Such right to speak is not unlimited, and public comment should be focused on the case and made as succinctly or briefly as possible. Although persons may be upset or even passionate about what they have to say, all witness testimony must remain civil, and you must not interrupt other witnesses, parties, or attorneys, including me. In most instances, if you are found guilty of a violation, the law requires that you be given a time to comply before a fine begins. You must abate the violation by that date, that is, fix the violation, or the fine will accrue for each and every day that the property remains in violation. The law allows Citrus County to impose that accrued fine as a lien on all of your property. The county has a right to foreclose on that lien or to seek a money judgment against you after that lien has been recorded for 3 months. I encourage everyone here who has questions about their rights or remedies to seek their own legal counsel because I cannot do that for you. In all cases in which I find that a violation has occurred, I will impose all costs required by county law. I incorporate these standard provisions into all my orders. If you bring your property back into compliance with the code during the time that I permit, that cost will remain minimal. But if you do not timely fix the violation, you will be responsible for additional costs, as well as the cost of the lien that's imposed. Although it's only happened a few times in my years as a special master, I may continue your case if I find the need for further evidence or argument. Are there appeals for orders to demolish? All right. You do have the right to appeal any order I make today as provided by law and as you heard earlier. Thank you.
First case on the day's agenda, Roy A. and Stacy L. Clyette, case number 217-3738, Code Officer Cody McGuire, page 13 of your agenda. Experts on the case, Sam Acosta, Certified Building Official, and Land Development Director, Joanna Coutu. Sam.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Can you please state your name for the record?
Stacy Clyette.
Thank you.
Good morning.
Good morning.
Morning.
Cody McGuire, Citrus County Code Compliance Officer. Case number 217-3738, Building and Building Regulations, Chapter 18, Article 1, Section 18-8A. Permits obtained after the fact permits for all construction or modifications of the Citrus County Code of Ordinances. Address is 10728 West Cary Lane, Crystal River. Property owner Roy and Stacy Clyette. Good service sign certified mail return receipt and posting at Lecanto Government Building. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos taken during initial inspection on September 13th, 2022. Follow-up inspections in Hanson on November 1st, 2022. And photos of my final inspection conducted on November 14th, 2023. A copy of the notice of violation. Exhibit B is a copy of notice of violation, copy of the notice of hearing, and a pre-hearing order.
Okay, ma'am, I'd like to ask you to take a look at these documents.
Okay.
He's trying to admit them as evidence in this hearing, so let me know if you have any objections to them being evidence. Take your time. This is for everyone's benefit. During your hearing, when the county seeks to introduce exhibits, I'll ask for you to review those exhibits and let me know if you have any objections. I'm asking for legal objections. You're gonna have the right to comment on them regardless. I just wanna know, do you think they're fake? Do you think they're not authentic for some reason? All right, so I didn't hear any objection to these. I'll admit them as evidence, exhibits A and B. Okay?
On September 30th, 2022, I conducted an initial inspection and observed the property to be in violation. I verified in Hanson that no permits had been issued. On September 30th, a notice of violation was issued for after the fact, which is a violation of the ordinance
Mr. McGuire,
listed.
let me just stop you. Did you say 30th or the 13th?
Yeah.
I think you said September 30th right now, but you had previously said the photos were from the 13th. Am I
The-
wrong?
The 30th.
Okay, all right. Maybe I misheard. Thanks.
On March 27th, 2023, I conducted a corrective action inspection via N4 and saw that no permits had been applied for or issued. I have had contact with the property owners in which they seem to be actively working on obtaining permits, but as of November 14th, 2023, the property remains in violation and no permits have been issued. I'd like to introduce Building Director Sam Acosta and Land Development Director Joanna Coutu.
Okay.
I could quote the code section from the Florida Building Code, 7th edition, 2020.
What is it?
Florida Building Code, 7th edition, 2020,
20. Okay,
that would require permits for the structure in question.
Is that the last edition of the Florida
That's the
Building
most
Code?
current.
Really? Okay.
It's redone every 3 years.
I mean, don't you require it under your own code? Yeah,
Yeah.
okay,
Okay.
alright. Okay. And you're Mr. Acosta, correct?
Mr. Acosta,
And you took an oath,
I'm sorry?
you took an oath, sworn oath, I just wanna make sure, alright.
Has testified before you before, so all good. Joanna Coutu, Growth Management. They have applied for a plat vacation because the structure lies in a platted easement. So on October 27th, we did receive a complete application. It's being reviewed by staff now. There's only one county commission meeting in December, so I think realistically, this probably won't go before the county commission until January for consideration of a plat vacation to allow the structure to remain as part
It's
of
on
the
a
permit.
platted easement?
Yes.
I see. So from the county's perspective, this was built without a permit on a platted easement. And so in order to have it approved after the fact, the county is going to require that the platted easement be vacated one way or that it go away.
Removed, relocated, or vacated, and they've chosen vacated.
And it's
so.
a private, I mean, it's what kind of
Public.
plat was this? A residential plat?
It's a residential plat. It's dedicated to the public as a drainage and utility easement.
Oh, okay.
Right, but we do have a complete application. I don't see any red flags
You
that will
don't know
stop
that,
it.
you don't think the county has any objection to vacating a
I
drainage
do
easement?
not, but I think formally we probably won't have the commission hearing till January, realistically.
I see. So there's really, if I'm thinking about a reasonable time, I need to think in terms of months.
Yes, it's
Okay.
gonna take some time to get to that hearing.
All right, Ms. Clyett, what do you have to say?
As Ms. Coutu just stated, that I have submitted everything to the portal for the easement vacate. I feel that right now we are just waiting on the time. And as it's on record that the new permit portal system is problematic, please let me know if I am missing anything.
Is it on record that
It
it's
is on
problematic?
record in the Chronicle.
I mean, does the county agree with that? Okay, there's no comment. That's interesting.
Yeah.
So let me just look through this. So the structure in question is the pole barn that I see?
Yes, sir. It's 7.5 feet into the drainage and utility easement, which I do own both parcels on either side of the easement.
I mean, what about the driveway? I mean, is the driveway?
Driveway is
Are you-
on one lot. It's not within the easement.
Oh, okay, so it just appears to me that the pole barn is totally over the driveway. Maybe I'm,
To the left of my driveway is the pole barn.
I mean, there's paving, but
Correct.
there's paving, so I'm calling that a driveway,
That's
just
fine.
FYI. Is the paving permitted? I don't care, by the way, I just.
Not in the easement, no,
Okay.
that's, if it would have been, would have been a lot easier to go through this, but no.
I agree, so I mean, is this gonna be,
The vacate will take care of all of it.
okay, all right. You're right, because if it's vacated, then.
Right.
All right, so what the county's basically telling me is they want me to find a violation, but give you enough time to fix it before any fine starts, which I don't have any objection with. How much time do you think you need to make sure this thing goes through the process?
So I have a question. Why can't it not be brought to the December BOCC meeting?
Well, that's not a question for this hearing,
Okay,
but what they're saying is it's likely going to be January.
January.
So I'm not going to put you in a situation where a fine starts accruing before the January meeting. So my inclination is to give at least 90 days. Is there any reason that you can think of that 90 days isn't enough for this to go through?
No, sir. That would
Okay.
be plenty.
I mean, is the county, am I setting her up to fail if I give 90 days? No. All right, so what's the county's recommendation?
Citrus County Code Compliance Division respectfully requests that the special master assesses a fine of $50 per day, along with administrative costs to begin after the date you deem sufficient to abate this violation. The amount was selected based on the actions of the property owners once they were advised of the violation. We'd also ask the special master additionally find that it's the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
Okay, I will find that the property's in violation. I'll grant 90 days from today to abate the violation by obtaining an after-the-fact permit, which sounds like it'll be doable and issued when the plat is vacated. I incorporate standard order provisions, $50 a day if it isn't brought into compliance.
After the 90 days, correct?
Correct.
Okay, just making sure.
All right, thank you.
Thank you.
Am I free to go or do I have to stay the whole time?
You do not. You are
Thank you.
welcome to leave.
Okay.
Yeah. Thanks.
Next case on today's agenda, Michael B. and Donna L. Caroni, case number 2198195. Officer Timothy Williams, Licensing Compliance Officer. Experts on the case, Samuel Costa, Building Official, and Land Development Director Joanna Katu, page 12 of your agenda.
Folks, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Can you please state your names?
Donna Carone.
And you, sir?
Timothy Williams,
Thank you.
Citrus County License Compliance Officer. Case number 2198195, Chapter 18, Article 1, Section 18-8A. Obtain after-the-fact permits for all construction or modification of the Citrus County Code of Ordinances. Address 9285 East Gobbler Drive, Floral City, Florida. Property owners, Michael and Donna Carone. Good service via signed certified mail return receipt. I would like to authenticate the following documents and request they be admitted into evidence. Evidence A, Exhibit A, photos taken during initial inspection on August 15th, 2023. Photos taken at my corrective action inspection on September 15th, 2023, a photo taken at a subsequent inspection on October 31st, 2023, and a photo taken of my final inspection on November 14th, 2023. Exhibit B, a copy of notice of violation, a copy of notice of hearing, and a copy of the pre-hearing order, and a copy of a certified mail return receipt.
And Mr. Williams, I just want to make sure I heard you right. Did you say you're a license compliance?
Yes,
What does that mean, and how is that different from a code compliance officer?
we do after-the-fact permits for contractors also.
Okay, all right, and, all right, so I'd like to ask you just to show these exhibits to, is it Caroni? The
Carone.
The Carones. And, Mr. and Mrs. Carone, let me know if you have any objection to these documents being evidence in this hearing.
Oh, this too. This was the, not the notices. The letter.
While we're waiting, is there anyone from the public who wishes to speak on this case? Okay.
Okay.
I didn't hear any objections.
No, that's
Okay,
fine.
all right.
Sorry.
All right, without objection, what's been proposed as exhibits A and B are evidence. Thank you. Please proceed.
Thank you. On August 15th, 2023, an inspection was conducted at 9285 East Gobbler Drive in Floral City, and photos were taken regarding a complaint of construction without permit. During my inspection, I observed a new boat dock and a carport. No contact was made with the owners at that time. no buildings permits were issued. And my corrective action inspection on September 15th, the property remained the same and still no permits were issued. On October 31st, 2023, I spoke with Mr. Carone at his residence, and he allowed me to take photos of the violations and spoke about correcting them. As of November 14th, 2023, no permits have been applied for and the structures remain. Our expert witness for this is Citrus County official, Mr. Samuel Acosta.
Mr. Acosta?
I can just state that a permit would be required in accordance with the Florida Building Code, 7th edition, 20.
They're not allowed to build these themselves without a permit.
They can build them themselves, but not without a permit.
Right, okay.
Yeah.
Mr. Williams, how did you know they were new when you conducted the initial inspection?
It's brand new wood.
It does look new, I would say from the photos. I'm just curious, is that the only way you knew that they were new, or that at least the boat dock was new?
From the complainant, when I first arrived at his home, I took a picture down the lake and saw the poles sticking up.
What about the carport? Or
That has been there for a while.
do you know how long?
No, sir, I do not.
Did, well, let me ask the Carones.
Yes.
So have you told Citrus County that you built both of these or arranged for these to be built without a permit? Have you told them that?
Start with the boathouse first.
Okay. I came to the building on August 7th
Mhm.
and signed in to inquire. I work for the county school district.
Okay.
And we had our opening day and everything. So as soon as that was over, I came here to see, do we need a permit? We had a dock. The dock was there, has always been there.
Wait,
it
I
was
just want to make sure I understand. Are you saying the boat dock?
boat
is-
dock. Yes,
You've
sir.
always had a boat dock there?
Yes, sir.
Not this dock?
Not this dock,
Okay,
because the
all
one
right.
that was there
It was
was,
falling apart.
Okay,
it was unsafe. We had a friend actually fell through part of it. We wanted to make sure it was safe.
okay.
And sturdy. And so, yes, we did inquire if we needed a permit to repair our dock and whatnot. It was called a boathouse on our taxes and such. It did have a roof over it at one time, so we thought, well, let's go ahead and if we're gonna fix this
Yeah.
dock, let's make it solid and put the roof back over it. So I did inquire on August 7th if we needed a permit. They said not for repairing and such, and I could call the waterway or find a company or if we needed that.
Who did you speak to at the county?
I have no idea.
Do you remember where you came and?
I came in the front building and then there's the glass windows there.
Yep.
And talked to somebody there and sat in the room until they called me up, like to the left.
Yep.
And
And someone
waited.
called you up and said that you don't need a permit?
And that's when,
to
right,
repair
they
it.
said it doesn't sound like,
Right.
yeah, it's anything that you would need a permit for.
Okay.
And so on. So then we got this notice, because our neighbor, we had a disgruntled neighbor who was turning on another neighbor and then showed him
That's how a
our
lot of
house
code,
from up
that's how a lot of code
4
compliance works,
houses
but it's
down
not
or
their
so,
fault.
you know?
People have to
No,
follow
I
the
understand
the
that.
law,
I
so,
totally
yeah.
understand that. And I mean, we looked into getting the permit. We certainly.
Let me add to
With-
this, one of the big reasons, she kept bothering me to get it fixed through the years. We had a friend actually fall through the dock.
Yeah, there was some
Oh, she
rotted.
mentioned that.
There
yeah.
was some rotted wood, so we
Are
needed
they
to fix it.
alive? Are they alive?
We replaced what needed
Did a
to
gator get them? Are they
be
alive?
replaced. No, he's
Okay,
fine.
okay,
He's
alright.
actually fine. but,
Is anything remaining from the
Yes.
original
yes,
dock?
Yes,
Yes,
there are.
there
And let me finish my question
Sorry.
before you answer it, by the way. It'll be better for the record.
Yes, sir.
I'll ask again. Does anything remain from the original dock?
Yes.
What remains?
There's
Hi.
quite a few posts, and there's also runners underneath, floor joists, from the ramp going to the dock that are the original ones. We left whatever wood that was still okay. We took out rotted wood. I don't think you'll see it in that picture.
Yeah, I'm looking for it. I mean, it all
Yeah.
looks pretty new to me.
Yeah, you gotta go actually underneath it you gotta go in the water to take the pictures.
Okay.
Which I had done at one point. We did contact, I talked to Mr. Williams. I also was in touch and have an email for trying to get, like engineering if we needed it, things like that. Talked to Suniva Brown.
Do you
is
know
it?
if you need engineering on this?
I honestly don't know, but
Okay.
we are looking into it. They
Well, no,
told
we're gonna
us-
find out. We'll find
trying
out
to-
today.
Trying to see, I mean,
Okay, so I understand the background on the dock.
yes.
What's the background on the carport?
There was a carport there, and we put up a new aluminum roof structure, or whatever it was, over it to replace and repair that. And we do have,
We've been paying taxes on
We-
it for,
we have the blueprints for that as well, and we purchased it. Looking for another.
Okay, but I'm
piece.
trying to, does anything remain from the prior carport?
no, that's
Okay.
all,
Oh,
it was
yeah.
all metal.
It was,
And that was professionally installed, and the company informed us, if there's something there, you could replace it, you don't need a permit. They gave us the architectural drawing for it. It's basically the same footprint that the old one was. And,
that was in 2018. And we did sign a waiver for the permit because we, again, were putting something that was there. and
What do you
we
mean
realized-
signed a waiver for a
From the
permit?
carport company, they had him sign a waiver, like,
right.
Florida Building Code responsibility waiver, not knowing that we,
Well,
because
I
they
don't know.
gave us
I'd be
everything
interested in
we.
reading that. I doubt it's gonna help you, but,
Just-
do you have a copy of that?
I do.
Would you wanna introduce it in evidence? It's up to you.
I
Do you
mean,
think it's relevant
Is it
for
gonna
me?
benefit us?
I have no idea till I
have
see
no
it.
idea. Um,
I'd like to see it, but it's
Okay.
up to
Well,
you.
yeah, it's basically a waiver that they said.
No, I'm curious what it
So
is.
shall
So,
we,
do you want it in evidence or not? Yeah, read that thing. If it's a waiver, like, hey, there might be building code issues here, but you waive our needing to deal with
Yeah.
them,
It says,
that's gonna be a
basically,
problem.
that's basically what it
But,
says,
you know,
That's-
but,
we put on their information
we-
saying that, you know, there was something here, you're replacing something that was here.
right.
You don't need
And
it.
here's the
I'd
blueprint
still like to
for
see it. I mean, let me tell you, I'm gonna find a violation, all right? So the question is gonna be how much time you need to correct it before a fine starts.
Oh, we
you
wanna
know?
correct that.
Oh, I know you
That's,
do.
that's
And
why I
so
came here on August
Yeah.
7th, to
Yeah.
make sure we're in
I
compliance.
would like to see the waiver. You don't have to let me see it, but I'd like to see it.
Well, if that's what, certainly,
Yeah.
I'm happy.
I mean,
to
does the
show
county
you.
have an objection? Can someone,
I'm-
Mr. Williams, would you mind
Do you want the
grabbing
blueprints
that?
and everything too?
Yeah.
Do you want the blueprints?
And I'd like, Mr. Williams,
we
I'd
got
like,
the,
no, just the waiver.
Just the way.
I would like to
Thank
ask you,
you.
Mr. Williams, for yourself and Ms. Antrim to take a look at that and let me know if the county has any objection to it being
Thank you.
evidence. Hey, okay, Mr. Acosta gets a look at it too. I mean, I would think that, I'm just very interested to see whatever this is.
I'm-
It sounds interesting.
it's-
Yeah, I think this is more relevant for me to understand the contractor and what they told you. It helps me understand what's going on. It's not gonna have an impact on your
It's-
case. but-
I-
It's a root structure.
It is a solid roof, it's a big large structure.
No, when they were doing just the decking, the stringers and stuff, as long as they didn't have any holes, they changed the configuration.
But they did a whole bunch of
If you got a
roofs.
roof,
I mean, is it what I think it is?
is-
but I just wanna see if.
Okay,
I-
I'm
what
gonna
does that mean?
I'm gonna admit this as exhibit 1. Let me just take a look at it.
That's that's over here, this is
Oh, no,
the
no.
entire roof. In this case, it's a huge structure with a big cover over the entire U. It's pretty large.
Did the carport company actually install the carport? Wow. I mean, they say here they don't install. That's what this document says.
Oh, no, they did.
They're trying to get around the code by saying that they just sell the kit and you gotta go find a contractor to do it or you can do it yourself. All right. Well, anyways, that gives me a little bit of background. Look, the reality is there's a code section here that says no person shall erect, construct, enlarge, alter, repair, move, improve, convert, change any building or structure subject to this code. And both of these structures are subject to the code. Now, if the dock had only minor repairs to it, based on your testimony about what the county allegedly said to you, I might find in your favor. But I can't see anything remaining. It doesn't look like a repair to me. It looks like a demolition and an entirely new structure. So I am gonna find that there's a violation for both of them. And what does the county want in this case?
There's someone from the public that would like this.
I know, thank you for reminding me. What does the county want in this case?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 per day, along with the administrative cost to be after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. We also would like to ask the special master to find that it is the respondent's responsibility to contact Code Compliance Division when the violation has been abated in order to allow for reinspection.
But what you want is for them to obtain after-the-fact permits on both structures, correct?
Correct, yes, sir.
Do you know about, and this is important for the public to know before they comment, do you know about how long that process might take?
For the carport, probably not long, but for the boat dock, they will probably need engineering, and that might take a little bit of time.
Okay. Again, before we get to the public, I just want them to have a full understanding of what we're talking about. Are you aware of any engineers who you can contact regarding the
Well,
boat dock?
that's been the whole problem. We already started this process, and to try to get somebody out to look at this stuff is like impossible, you know? Actually, the county, gave us a few phone numbers that they had recommended when we first got and I called every one of those numbers, we don't do that, try calling these people, try calling that people. And I guess they're so busy in the county, I guess with all the new, buildings that are going up in housing, you know, it's like nobody wants to touch this little
Okay, so I now understand your perspective. I would like to hear from the public. Sir, would you like to come up and be heard? Probably this one.
Yes, sir. My name, sorry,
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your name.
My name is Greg Hoying. I live at 9465 East Gobbler, just down the road. I've lived there since '04. And I know the house the Carones live in was formerly known as the Byron House. And I'm here to testify that that boat dock and that carport was there since before then. And I know that the dock was unsafe. And Mr. Carone repaired it because he didn't want anybody to get hurt. So that's really all I have to say.
All right, I appreciate it. Yeah, I don't think anyone's imputing bad motives
No,
to you guys,
again,
just so you
Started
know.
this whole
Yeah.
thing, you know, a neighbor, and, what happened was our other neighbors next door to him, his wife was getting assaulted by this guy. I was called by her husband, who worked in Pinellas, to go see what's going on. By the time I got there, the sheriff's office was there, and because of my involvement trying to help my neighbor, which we had been friends for,
Since we moved here.
20 years, that's why he called on me, just to get him. And he's currently sitting in the county jail for,
Assaulted.
Well, you know what they say, no
brother.
good deed goes unpunished.
Exactly,
So,
right? It's funny too, because
all right, I mean, the issue is in giving the amount of time that's needed to abate the violation. It is based on the testimony regarding the engineering. Essentially, what's going to need to happen in the time I allow is either you're gonna have to get it permitted with
Which-
proper engineering, or in order to abate it, it's gonna have to come down. So my job is I want to try and give you enough time. All right, I'm gonna find a violation based on both the dock and the carport. And I will grant, I really don't have a clue how long engineering and something like this takes. Once you receive engineering, how long does the review take?
If it's brought to my attention, I can certainly expedite the process, but I think applying for the permit is an act of good faith towards getting it resolved. And so perhaps that might be taken into account for the ending of the fine.
I see what you're saying.
We would apply for the permit right now. What
Yeah,
do we need to
I
do?
mean,
I came here in
unfortunately,
August trying to
it's-
get one.
That's,
Yeah, we.
With the intent to get it in
that's-
August,
I
was
came to
here.
get one
I
and,
think 6 months is.
6
you
months.
know,
I'm-
and
we're
now
okay
we
with
find
that.
ourselves
And-
in this mess.
Had no idea we couldn't replace.
are there any, is the county aware of any immediate safety concerns regarding the dock? Obviously, I understand the county's position that there's a presumption when something hasn't been permitted, but is the county aware of an immediate health or safety concern on the dock?
I don't think so with that dock.
Okay. I'm going to allow 150 days to bring them into compliance. And if it's not brought into compliance, a fine of $50 per day will accrue. All right, thank you.
Thank you.
Good luck.
Thank you.
Next case on today's agenda,
It's evidence.
Gary G. and Jenny R. Gowans, case number 2023-00711. Licensing Compliance Officer Keith Gardner, page 20 of your agenda. Expert on the case, Building Director Samuel Costa.
Sir, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Can you please state your name?
Gary Gallons.
Thank you.
Good morning.
Good morning.
Good morning. My name is Keith Garner, Citrus County License Compliance Officer. Case number CE, Codes Enforcement 2023-00711. Chapter 18, Article 1, Section 18-8A. Obtain after-the-fact permits for all construction and modifications of the Citrus County Code of Ordinance. Address is 11292 West Pool Court, Crystal River, Florida, 34429.
And sir, just I've never met a licensed compliance officer before, so I just want to understand. Is it your duty to assure compliance with county codes?
Correct.
Okay, thank you.
Licensing and Wright County codes. Property owner is Gary G. and Jenny R. Gowans. Good service posting at the property and the Lecanto Government Building. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos taken during an initial inspection on August 21st, 2023. Photos taken at my corrective action inspection on October 16th. A photo from the property appraiser site and a copy of the approved sketch. And photos taken of my final inspection on November 14th, 2023. Exhibit B.
When you say approved sketch, what's an approved sketch?
Was part of the permitting
Okay.
of what was supposed to be built,
And
right?
when you say approved, like approved by the county?
Right.
Okay.
Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, and a copy of my posting affidavit and photos of the notice of hearing posting at the property.
All right, so sir, you've seen how these go. I just want to have you take a look at these documents and let me know if you have any objection to them.
Okay.
No objection.
Thank you.
Would I be able to get copies of those?
You can request copies as
Yeah,
they're
would you?
public records, so.
Okay. If you wouldn't mind, Mr. Garner.
Is that good enough for a public records request for y'all? I mean, I'm not a county attorney, so it's not my job to advise. All right, without objection, what's been proposed as exhibits A and B are evidence. Go ahead.
On August 21st, 2023, an inspection was conducted at 11292 West Pool Court, and photos were taken regarding a complaint of dock construction with a cover and floating dock, permit number 2021-15343. It had been issued but expired without inspection. No contact was made with the owner during my inspections. Mr. Gowans came in on Monday, November 13th, and spoke about the dock. As of my final inspection on November 14th, no permit had been issued for the dock and still remains in place.
Okay, what happened in the conversation on Monday?
Just, he was not aware of this being a problem because he had just gotten this notice.
And he had the permit.
He had the expired permit.
Is an inspection being scheduled to go out?
At this point, the permit would need to be reissued
Okay.
and then reevaluated, and then it could be inspected.
All right, let me just take a look at what has been provided to me.
An expert witness for the case is county official Sam Lacoste.
All right,
It's my understanding that the permitted set of plans and the configuration that's out on, that's actually exists is not
the same.
the
Less
same,
than
correct,
construct,
okay, so,
Okay.
it would require,
Okay, all right.
corrected plans to be submitted to that.
All right, I understand what the county's position is. Let me take a look at these documents before I just want to understand. From the county's perspective, how does it differ from the approved when it was properly permitted?
The floating dock is not in the right spot.
Okay.
I'm not sure what, as far as what was built by the permit, but it needed to be inspected to make sure it was built by what was submitted.
Now, I'm not an engineer or, I have no qualifications whatsoever except that I'm a lawyer, which really unfortunately means nothing. If it's a floating dock, doesn't that mean that it may be able to move a little bit or?
Well, as you can see, it's tied in place with the post, so that floating dock is where it's going to be. It just goes up and down where it's.
Oh, I see. Okay. 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 How far off is the floating dock?
Looking at the drawings, it's way off. It shouldn't be out where it is. It should be up underneath where the walkway is.
Okay, I mean, I think I understand based on the photos what's going on. Is it Gowans?
Gallons.
What's your perspective?
We were on an extended trip
Mhm.
and returned to our home in Crystal River on Friday afternoon around 4:00 and saw this notification on
Yeah.
our lawn. And I called the office right away, thinking they were still open. I forgot it was Veterans Day.
Yeah.
And so Monday morning, I came over here and met with Mr. Garner. And I guess what I need is, this just came on me like a ton of bricks. Can I get an extension to address all this?
You're gonna get time to fix it.
Okay.
I
mean,
guess
I would like to do that.
you're gonna get it, but my question is, it appears, I think I understand the county's case that the floating dock is not where it should be.
Right.
But it doesn't even, it looks so far from where it should be that I don't even know if it's on the property line. Is it on your property?
Yes, it is.
Okay,
Yeah,
okay.
we were meticulous in making sure that it was not infringing on
Okay.
anybody else. when
But
we-
do you
when we
agree
did
that
this.
it doesn't follow exactly what was permitted?
Well, I guess, I had thought, this all was taken care of by a contractor, which is Dock Masters, Inc. And we were under the impression, since we had the permit sitting in our yard for forever how long, that he was taking care of it. There was a change, I believe, in that we found out we had more room than we thought we had, and that we could arrange this platform as it sits now without hurting anyone. I was under the assumption that Dock Masters reapplied for a variance into the permit. and that
Oh,
was
I now
granted.
understand. I was looking at a different floating dock or something that I thought was floating. Oh, it's not far off at all,
Would
but
you
it,
like me to?
no, I understand. I
Okay.
understand. And it is, I can see why they say it's in the wrong place though.
Yeah, and I would like to get it rectified, but I
Okay.
need some time. if I
Okay,
can
how much
do
time
that.
do you need?
Well, like everybody else, I'm at the mercy of these guys. 90 days, 120 days, I don't know.
I mean, he needs a permit.
Reissuing of the permit, the permit would expire in 6 months once it's reissued.
Right.
So if it was completed, once it's reissued.
I mean, do you know of any reason why it couldn't be permitted after the fact based on where it is, assuming you got new plans or?
I wouldn't be able to testify to that, but I would say 90 days would be about the minimum.
I mean, the floating dock is now
Right.
right against the property line, essentially, as opposed to in front of the dock, under the
Right.
overhang and everything. I mean, I'm just curious if you're aware of a reason why it would need to be where it was shown on the prior plans and not where it is now.
That would be up to the inspectors.
Okay.
Once they submit.
So you're not
what
aware?
Needs to be submitted.
But you're not aware, yes or no? Okay. All right, what's the county's recommendation?
Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 per day along with administrative cost to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given the severity of the violation and the respondent's actions related to this violation. We would also ask the special master additionally find that the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
Okay, I am gonna,
What
go
was the
ahead.
dollar amount? I'm sorry.
50.
Okay,
And so I am gonna find that the property's in violation. I'll grant 90 days to abate the violation,
Okay.
which either means you have to get this properly permitted or remove it, assuming that's allowed, and that'll
Right.
abate the violation.
I've talked with Dock Masters. I mean,
Okay.
after meeting with Mr.
Okay.
Garner, the next stop was Dock Masters. They thought that everything was inspected and everything was on the up and up.
Yeah, hey, get
I
a
didn't know.
discount or
So-
a refund. But in any event, if it's not
But
brought
they're
in,
gonna look into it.
okay, if it's not
and,
brought into compliance as ordered, a fine of $50 per day will accrue on it.
Okay.
So you've got the time you requested.
If it takes longer than that, can that be?
I would just talk to the
extended?
county.
to
That's
the
gonna be my order, so I expect them to follow my order.
Okay,
If y'all wanted, you could jointly ask me to change the order,
okay.
okay?
We,
That-
I'm sorry, excuse me, we have someone from the public also.
Oh,
that
I'm
wants to
sorry.
speak.
Yeah, gosh. Is there someone from the public who wishes to speak? I would like to hear from you. Thank you. They need to jump in front of me sometimes because the train starts moving.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Your name, please?
Teresa Naylor.
Thank you.
Thank you, ma'am.
I'm the adjoining neighbor to the Gowans. They live on the long side of the canal, and their property line ends at the corner, and we're on the short side, so we're adjoining. The dock,
You're the owner. Are you the owner of the property that can be seen in these photos? Do you know?
Correct.
Okay. You took the photos from her property. Okay. That makes sense.
It's my contention that the dock was deliberately placed in that location to block our access to our dock, based on previous experiences with the Gowans, where they moored their boat to block us, and then purchased a pontoon boat that didn't have a motor on it, and chained it to their chain link fence to block us prior to the installation of this dock. I have got photos I'm happy to share. Again, it's blocking our access to navigable water. I'd also like to point out this permit expired in June of 2022. The Gowans proceeded to use it from that point till now without it being properly permitted and inspected. And I have photos I'm happy to share.
I appreciate if you wanted to introduce evidence, it'd have to be up to the county. They'd have to adopt whatever you want and then introduce it as evidence. You don't have standing as a member of the public to introduce evidence. This is something I've researched recently due to another hearing we had where I made a mistake of introducing evidence from the public. In any event, does the county wish to introduce any evidence from the public? Have you reviewed what she wants to introduce? Okay.
I think we'd be mixing civil matters with code
Yeah, I
enforcement.
think I have an objection to that as
Well, you have a right to be heard, and like I said, I'm not going to allow it regardless unless it's introduced through the county. Thank you, ma'am.
Thank you.
You know, you have a right to respond.
That's a completely different matter than this issue here. And I don't think any of those photos would lend any credence to.
Well, I'm just
the
mean,
difference here
do
with that.
you can, if you wish, and you don't have to, you have an opportunity to respond to the public's comment.
Right, okay. It is our opinion and our attorney's opinion that we are not encroaching on anybody's rights to place a dock anywhere on the waterway.
Okay. Who's your attorney?
Kevin Dixon.
Okay. I mean, when I look at the photos of the approved sketch that the county permitted, I mean, I could be wrong, but it appears to me that it would possibly affect,
Well, if I may.
I don't know, but I mean, it
Yeah.
may affect the navigable ability of the neighbors even worse than where it is now. If he had built it according to the permit.
Well, there was a bit of a change, and our contractor knew that. Originally, we had a 10-foot setback with the neighbors on the other side because they have a boat lift dock or boat lift house. And we wanted to make sure that we had enough room for both boats to be able to pull in. As it turned out, when we started construction, the contractor said, hey, we have a little bit more room here. So instead of a 10-foot setback from the right side neighbors, we made it a 7-foot setback, which gave us 3 extra feet on the other side where the floating platform is. And that's why it was built out from the roof line and put in there. But it is our opinion that it does not encroach on anybody's water rights.
Okay. Well, I don't know. I can't tell. And
Yeah, you can't from those pictures.
well, look, the violation has been found. I'm going to stand by 90 days to fix it. And if it doesn't come into compliance as ordered, a fine of $50 per day pursuant to the county recommendation is going to be had.
That's fine,
All right.
thank you.
Thank you.
Next case on today's agenda, Karen J. Snyder, case number 2194642, licensing compliance officer Keith Garner, page 33 of your agenda. Expert on the case, certified building official Samuel Costa.
Schneider? Oh, I'm sorry. It's okay. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you.
I'd like to know at the onset, is there anyone from the public who wants to be heard on this? Because I clearly didn't have enough caffeine this morning.
I didn't
All right,
either.
I don't see any. And ma'am, what was your Miss Schneider?
Karen Snyder,
Okay,
yes.
thank you.
Keith Garner, Citrus County License Compliance Officer. Case number 219-4642, Chapter 18, Article 1, Section 18-8A, obtain after-the-fact permits for all construction and modifications of the Citrus County Code of Ordinances. Address is 1160 West Geneva Place, Citrus Springs, Florida 34434. Property owner Karen Schneider. Good service via signed certified mail return receipt. I would like to authenticate the following documents and request they are be admitted into evidence. Exhibit A, photos taken during an initial inspection on June 16th, 2023. Photos later taken on August 25th, 2023. And photos taken at my corrective action inspection on October 13th, 2023. Photos taken at my final inspection on November 14th, 2023. A copy of the notice of violation, a copy of the notice of hearing, Exhibit B. A copy of the notice of violation, a copy of notice of hearing, a copy of their certified mail receipt indicating good service.
Okay, ma'am, I'd like to ask you to take a look at these documents and just let me know if you have any objection to them being evidence. Take your time.
It's the structure.
I have a question for you, Mr. Garner. I'm reading this code section here, and it says that any person commencing construction for which a permit is required without having first obtained such permit, in addition to the penalties described in this chapter, shall also be subject to a penalty equal to double the permit fee. That hasn't been asked in any of these, and I haven't ordered it. Is that something the county expects it? I'm sorry, sir. Is that something that the county expects to be ordered in these cases?
That's what we do when we find it after the fact. We put it in as a fee, and then when they purchase the permit, it's a double fee on the actual permit.
It's applied at the time of permit application. If they've stated it's after the fact.
It's the county's position, I don't have to order it?
No.
Okay, I'll look into that. I mean, I'm just interested.
Just
Yeah.
curious.
All right, Ms. Schneider, have you had a chance to look at those documents?
Yes.
All right, do you have any objection to them being evidence in this hearing?
No, the only thing is, I never knew you had to have a permit for above-ground pool.
May I correct myself? I mean, I meant to say, I'm not saying it's not required that you ordered it, but if we requested you to, you could.
I see. Is that what you're saying?
Yeah, well, yeah.
Or are you asking me?
Both.
I'm gonna read it and try and figure that out for myself in just a minute.
Okay.
All right, and by the way, Ms. Schneider, you're probably not the only one, but the code says what it says. I mean, this is, look at this. You're basically you're responsible for this. Every person in Citrus County has to follow all these, it's
But as soon
natural.
as they told me that the county guy came out and told me I needed to get a permit, I did.
Okay, well, let's
Okay.
let me understand the county's case before we get into that. Thank you, Mr. Garner. And I'll let the county proceed as I look through these documents.
On June 16th, 2023, an inspection was conducted at 1160 West Geneva Place. Photos were taken regarding a complaint of construction of a pool without permit. During my inspection, I observed an above-ground swimming pool inside of a fence. Permit number BLD 2022-05986 had expired without inspection. And Ms. Schneider had the permit reissued and fees were applied, but was never purchased. Contact was made by the owner, yet no building permit had been issued. Ms. Schneider came in yesterday, the 14th, and purchased the permit. An expert witness in the case is County Building Official Sam Acosta.
Okay.
A permit would be required for the above ground pool.
Okay. And just so I understand our posture here, so it was built without a permit, or was it built and not finalized?
It was an after the fact.
It was an after the
Built,
fact.
Right, it was built and then the case was opened by another county employee that's no longer with us.
Who's that?
I want to say it was Joshua.
Okay. And so there was an after the fact permit issued, and it was not actually it wasn't purchased. I'm trying to understand.
The first permit was issued and expired without inspection.
Okay. Do you know if it was built at that time after the original permit was
Yes,
issued?
it was.
It was, okay. And so after it expired, then an after the fact permit was pulled.
She had the permit reissued.
It was reissued.
Right.
Yesterday?
It was reissued but never purchased. She just came in yesterday to purchase it again to have it reissued.
Okay. So it's now been reissued and purchased.
Correct.
What does the county want from me? If she's had the permit
Has
reissued?
it been issued?
It's not been issued yet. She
Okay.
just purchased it.
Okay.
I'm sorry.
Is the county aware of any reason why it wouldn't be reissued?
Not at this time, but until it's issued, it still remains on my.
Is there any action that the county expects the owner to take at this point? Or is it all in the county's hands?
Right now, it's probably on the county's hands since she's purchased it, but it's just been so much time had passed.
All right.
Is all that's required an inspection at this point?
No, the permit has to be issued.
Yeah, that's an administrative procedure on our part, and I think. that
So there's
they-
no inspection that's required?
Oh, yes, there is an.
There is an inspection,
Yes,
and that hasn't been done yet.
No, it
So it's got to
hasn't been.
pass inspection.
Administratively, it hasn't been issued. It's been, the fees have been assessed.
Okay.
been paid, so it's administrative
All right.
issue to pay or to issue.
And that means there's a possibility it might not pass inspection, that it
That-
might still require some work.
That's correct.
Does that make sense, Ms. Schneider?
Yes, but I picked up the permit yesterday. And the lady told me I had to put it to where it faces the road so they could see it.
I'll tell you, I'm super confused by this because I thought that when you actually have a permit in hand, that is the end of it. Sounds like she's saying she has a permit.
You have a permit card that gets posted on the job site?
No, I came here yesterday and paid for the permit.
Okay.
See,
You do not have a permit in hand.
no, it's at home.
The expired permit is at home. She does not have it reissued.
Okay.
Well, why didn't they tell me that yesterday?
All right. So what's going to happen is it's now in the county's hands to begin. You're doing the right steps, okay? But it sounds like the county needs to do an inspection.
Yes.
Who knows what it might turn up? I mean, it may say there's some issues that have to be fixed. So my job is to give you a reasonable amount of time to make sure this process can play out before like a fine begins to accrue. How much time, if you know, do you think this process might take? I'm going to ask the county as well.
Well, I need to clean a pool. I mean, it's, it's kind of nasty and everything. 30 days or something. Well, the holidays are coming too, so.
Yeah, that's a.
Let's.
All right. I know the county can't tell me with certainty, especially since you haven't done an inspection yet. But how long does this process normally take?
I think that if once the permit is issued, the normal permitting process will resolve this issue. Because once
I
it's
know.
issued, she's good for.
I know it'll resolve the issue.
Yeah,
What
but
am-
but the permit's good for 180 days at that point.
Her permit's been issued,
Yeah.
sir.
So-
I just verified her permit's
I do
issued.
have the permit then, right, sir?
It's issued.
Yes.
Why hasn't that been?
Picked it up yesterday.
Yes.
Why
ma'am.
hasn't that been told to me?
Yes.
Why didn't the county say that the permit had been issued?
I was not under the impression that it had been issued, that it had only been paid for.
Okay.
That was my mistake.
There might have been a delay in the record process.
Okay. I mean, that's fair.
We just seen it, it's been issued just now.
I have no problem with that, by the way. I just have a problem with incorrect testimony, because I rely on that. These are important things for people's property. Does that abate the violation?
Yes, sir, at this time, yes.
Okay. Then I'm not going to look at the fee issue, since it sounds like it's already been paid, and I'll dismiss the case. Okay?
Thank you.
Thanks.
Thank you.
Yep.
Yes, Sam, I think that's it for you. Yes, sir. You're good. Yes, sir. Thank you. Next case on today's agenda, Angel Luis Jr. Estevez, case number 2023-00470, Code Officer Brandon Norman, page 18 of your agenda. Expert witness on the case, Joanna Katu.
Sir, Mr. Estevez,
Yes, ma'am.
thank you. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do. Amen.
Thank you.
And sir, can you state your name for the record, please?
Angel Luis Estevez Jr.
Thank you, sir.
Good morning.
Good
Brandon
morning.
Norman, Citrus County Code Compliance Officer. This is for case number 2023-00470, Development Applications Applicability, a violation of Chapter 4, Section 4002, A, B, and C of the Citrus County Land Development Code. This is for address 6577 East Gentry Street in Inverness, Florida 34452. Property owner listed as Angel Luis Estevez Jr., and I have good service via signed certified mail return receipt. I would like to authenticate the following documents requested be admitted into evidence. Exhibit A will be photos taken during the initial inspection on July 20th, 2023, the corrective action inspection on September 5th, 2023, and my final inspection done yesterday, November 14th, 2023, as well as aerial images from the Citrus County Property Appraiser website for June 6, 2023 and June 26, 2023. Exhibit B will be a copy of the notice of violation, a copy of the notice of hearing, a copy of the pre-hearing order, and a copy of the signed certified mail return
I
receipt.
want to make sure I got the dates right. So the aerial photos were from June 6th and June 26th, 2023?
That's affirmative.
Okay. Sir, what I'd like to ask you to do is, I mean, you've seen how this works. Take a look at these documents and let me know if you have any objection to them being evidence in this hearing. Take your time.
I have no objections at this time.
Okay, thank you, sir.
Yes.
Is there anyone from the public who's going to want to be heard on this case? All right, let the record reflect there's no response. All right, thank you. Without objection, what's been proposed as exhibits A and B are evidence.
On July 20th, 2023, I conducted an initial inspection of the property for complaint of site modification without permits. The property was found to be in violation of the above ordinance due to not have any permits issued before the removal of trees and the modification of the property. The aerial photos show the trees were removed between June 6, 2023 and June 26, 2023. I have had contact with Mr. Estevez and he has stated that he has no intentions to develop the parcel at this time. I have informed him of what needed to occur in order to abate the violation.
What did need to occur in order to abate the violation?
He needs to obtain a site development permit,
Site development permit.
or else we would ask for the one-time fine for the irreparable damage.
The county, I mean, I'm going to hear from him, but you're going to end up asking for a one-time fine.
If his intentions are still not to obtain a site development.
I see. All right. Does this make sense?
Yes, it makes very sense. As far as intention of building, I have no intention of building. The reason I took down those trees was safety due to my neighbor, also the neighbors in my neighborhood, because those trees that were taken down were very tall pine trees. And they were very close to the power lines because of how tall they were. When I say how tall they were, I also got photo evidence. They were like very tall, but again, I feared the safety of my neighbor next door to the. I'm in Orlando, so it's one less worry, and that's why I've taken down those trees. But I was not aware about the city regulations, the county regulations on taking down trees.
Right.
Again, I have no intention on building on that property. It was just for safety reasons.
I mean, it makes sense to me. I can understand. Nonetheless, it's the code section does apply here. So when again, you heard earlier today that no good deed goes unpunished, and it's just that the reason they need a site plan, because when you take down trees, it may affect things. It actually may affect neighbors as well. It may affect all kinds of different things on a property. I'm not an expert in it, but that is the presumption behind the law. What's the county's recommendation based on what it's heard?
The Citrus County Code Compliance Division respectfully requests that the special master assess a one-time fine of $5,000 along with administrative costs to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation, as well as the irreversible and irreparable damage caused by the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to this violation.
I think based on the testimony that I've heard regarding the reason, which I can understand, and I can see the trees being very tall on there and also bending and potentially being vulnerable for I'm sorry, does someone else from the county want to testify?
My expert witness would like to make a statement. Joanna Couture.
If I could, I apologize, Joanna Couture. Just FYI, in the statutes, there is a provision for that specific situation. You have to have a certified arborist or somebody that's certified to say the trees are a danger to humans or the ground or the property on the ground. You bring that in hand, and then we're like, okay, check, it's a danger, you go. So there is a provision in there.
Is that in the Citrus County Code?
It's slightly in the code, it references it, but it also is in the statutes.
Do you happen to know where
It's
it is?
in the tree preservation section, I'm sorry, I have to come over and look over your.
No, that's okay. It'd be helpful. It will impact how I deal with
Right,
this.
that's where I wanted to speak up.
Yeah,
I apologize.
it's okay.
Go on your code. We have following a reversible dead are listed as invasive, and then we also have, it's in statutes more than this then.
Yeah,
That's
and
what
I-
it's there.
And in
There's
the
a-
last 2 years, in the statutes, that's been.
Right, right.
I would
It is-
love
it is
to
a relatively
know-
new part of the statutes.
I would love to know the Florida statute. So there's a Florida statute that permits the removal of trees when they could be a danger to the neighbors?
Right, provided that certification is provided to the
Mhm.
local jurisdiction saying that, yes, it's a damage to either property or people on the ground.
They don't need a permit, they can just take them down.
If
If that's
they have that,
certification.
yes.
Wow, okay.
It used to just say people, now it says people and property. So if you feel it's a danger to something on the ground and it's not defined very well, then you can get that from say an arborist saying that's damaged or needs to come down.
And it has to do with residential property, I have it up.
Yeah, it is residential.
What's the number? What's the Florida statute?
163.045.
If you don't mind, I'm just gonna look at it real quick. It's not that I disbelieve anyone, by the way. This is an academic question for the county, but is it possible to get an after-the-fact certification? I mean, has the county ever considered that?
No, we haven't. This is a new statute. We haven't had it applied very much, and we haven't had that even considered that.
Then what I'm gonna do,
I don't know how, I'm sorry, I don't know how they certify it already removed. That would be the problem for that arborist or whoever to certify the trees that are now gone.
Okay, well, this is interesting to me. Go ahead.
No, I hear you, and I hear what everyone's saying. Again, I got the property.
They're speaking in your favor, by the way.
No, I appreciate it. Thank you, everyone. But I got the property November last year.
Okay.
But as I'm seeing, the county seems to be changing a lot of these things. Not things, statutes. Was it, if I'm hearing it correctly, 2 years ago it was put into action?
Well, it sounds recent.
Okay.
It go back to 2019, but it was amended in 2022.
Gotcha.
And I think it had to do with the arborist certification.
Yeah, so, I mean, in the future, on your other properties, that's what you do. Get the certification from the arborist, give it to the local government jurisdiction, whether it's a municipality or a county. But my job is to apply the law as it is. I am gonna find a violation, but I'm gonna reduce the fine to $500. Okay?
Okay, that sounds great.
All right, thanks.
Thank you very
Thank you.
much.
Yep.
Thank you.
Next case on today's agenda, Jeffrey W. and Tracy L. Kirkpatrick. Case number 2023-00628. Code Officer Julie Wilkinson, page 21 of your agenda. Expert on the case, Land Development Director Joanna Coutu.
And while we're waiting, is there anyone from the public who wants to be heard on this case? Just so I know. All right, let the record reflect I see no response.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Please state your names.
Jeffrey W. Kirkpatrick.
Tracy Kirkpatrick.
Thank you.
Mr. Special Master, I had a chemo treatment yesterday, so I'm gonna request to sit down and if
You
may, I might
absolutely,
put
take a
up-
seat, yeah. Thank you.
Thank you.
And if you need to be heard, we do usually need things in the microphone, but we'll make sure that you're heard. Oh, she's got, thank you, sir.
Yeah.
All right, we're good, appreciate it. And let me know if you need anything
Thanks.
else.
Okay.
Free money I can't do. I don't have the ability to give anyone money here, unfortunately, but, okay. Yeah,
Julie Wilkinson, Citrus County Code Compliance Officer. This is case number 2023-00628, special requirements for all accessory structures. A violation of Citrus County Land Development Code 3102A. The address is 10937 South Riviera Drive, Homosassa. Property owners Jeffrey W. and Tracy L. Kirkpatrick. I have good service via signed certified mail return receipt. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos taken during an initial inspection on August 8th, 2023. Photos taken during a corrective action inspection on September 6th, 2023. And photos of my final inspection conducted on November 14th, 2023. And an aerial of the property dated May 29th, 2023. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the general pre-hearing order, and a copy of the signed certified mail return receipt.
sir, I'd like to ask you and ma'am to also look at these documents and let me know if you all have any objection to them being evidence in this hearing. She'll take them up.
Okay,
Yeah,
thank
thank you.
you. Yes.
You have any legal objections?
Yes,
to
I
these?
do. I
You
do.
Okay, what is it?
I did not know about this till yesterday morning. The certified mail was sent to our old address and somebody signed for it. And the code enforcement officer will tell you how I found out about it yesterday.
Okay.
So I was unaware of anything. There'd been no signs placed on the gate. They something about emailing us. We had no emails, and nobody had ever put a sign on the gate or fence. And it was signed by a bogus
Okay.
somebody. So
All right, we'll get into
I found
that.
about 9 o'clock yesterday morning.
So we'll get into that.
Okay.
So I will construe that as an objection to Exhibit B.
Okay.
In other words, the notice of violation, the notice of
Yes.
hearing.
Yes.
But on Exhibit A, do you have any objection to photos?
No, not
Okay.
at all.
Okay. So without objection, Exhibit A will be evidence.
Yes.
We'll take up I'll reserve ruling on Exhibit B after we talk about it a little bit.
Okay.
The notice issues, in other words. The address that's on this is Hernando Beach, 4077 Orient Drive. Is it your testimony you don't live there anymore?
No, sir.
Okay.
No, no.
All right. Do you know if that's the address on the property appraiser website for it?
It had been, but we've in the process of correcting
Yeah,
that.
you have not corrected it.
No,
correct?
no. I mean, this has all happened
All
pretty
right.
quick.
Then I have to overrule your objection because they're entitled to send notice to where the property appraiser has the address.
Oh.
That's how it works. So that's why it's important to keep it up to date.
Okay.
All right.
Yeah.
It's irrelevant. It went to the right address. And if you have a problem with who signed it, you need to get rid of them or do something. Well, I take that back. Not
Okay,
get rid of
thank
them.
you very
You don't
much,
live there
sir.
anymore.
Thank
I'm
you
not
much, sir.
advocating terrorism. But it's not a legally cognizable objection because it went to the correct address. So
Okay.
that's your fault, not the county's.
Okay.
All right.
All right. Thank you.
Yep.
On August 8th, 2023, I conducted an initial inspection and observed a mobile, excuse me, and observed a mobile home had been brought onto the property as well as carports and utility-type buildings. And on August 14th, 2023, a notice of violation was issued for special requirements for accessory structures, which is a violation of the ordinance listed above. On September 6, 2023, a corrective action inspection was conducted with no change to the property. On November 14th, 2023, I was able to make contact with the property owners. As of my final inspection on November 14th, 2023, the mobile home has been removed, but the other structures remain on the property and the property remains in violation. When I went out there yesterday to conduct the inspection, I actually observed the mobile home being removed from the property, and there was a gentleman there. So I walked up to him, and he identified himself as Tony, the property owner's nephew.
Yeah.
Okay.
So I then asked him if he was aware of what has been going on with the violations, and he said no. And I said that I had been attempting to get a hold of the property owners, but that I had had good service. Someone has been signing for the mail. So then I got the contact information for the property owners from their nephew, and I gave them a call yesterday. And I discussed everything, told them that this case is coming to hearing today, and it would be in their best interest to show up so they could tell their side of the story. And here
And they're
we
here.
are.
Yeah.
Yeah.
Let me ask you, so just before I talk to them, I want to understand the county's case. And is there any other testimony from the county?
Yes, Joanna Katulin.
Great.
Joanna Cotillion Development. This is 20 acres in CL, low intensity coastal and lakes. And that's what's key here. They've applied in 2022 and also in 2023 for a mobile home permit. It's not zoned for mobile homes. So both times they had to be denied. 2022, they eventually withdrew. The 2023 case has been closed because they cannot be approved as a mobile. They can do a site-built home here or a modular, but not a mobile home here.
Okay. And so because there has been no principal use established,
Correct, right.
nothing can be on this property.
Correct.
And that includes fences?
No, not fences.
Fences are okay.
Fences, yeah, you can secure your property.
All
but-
right, so I just want to understand what the violation is at this point. Oh, it's storage?
Right, all the items.
So anything, parking vehicles, that's a violation. Trailers, that would be a violation, correct?
Yes, and when I spoke with Tony, the nephew, yesterday, he had told me that there's also Connex containers on the property, which I have not observed because of limited visibility.
Okay. Does this make sense what the county's saying?
It makes sense, but it's funny. I've already been taxed for the connexes in the outbuildings and have paid these taxes. And now we're this far down the road. what drawed the attention to it, and like the other people that's been here, contractors and salesmen have told stories, stretched truth. I went to Family Home Center here for my daughter. It's not for me and my wife, it's for my daughter. When I walked in, the salesman, oh, yeah. And he turned his computer and said, oh, yes, we can put a mobile home there. And I've done this twice, like she said. I closed that one out because the deal went south. And my wife got cancer and my dad died, so we canceled that deal. So that's why it got canceled. I didn't know all about the wetland, whatever, coastal stuff.
The zoning issue.
Yeah, so we canceled that. But the next time, her cancer's better. We're on triple lifetime. My dad's passed away, so we're on triple lifetime. And I'm in Yellowstone National Park and get a phone call that it's been denied. When I go back to the salesman, he turned that screen around and said, oh, yeah, no problem. It'll go here perfect. So I hired their permit people to do all the permits because I don't know nothing about zoning and permits. So their permit people was when they called me and said, oh, we can't put it there. So since that time, we spent $65,000 to move the kids 3/4 of a mile down the road. We've got the proper permits. She witnessed the home being moved there. So now we're back to square one.
The home is in a place where
Yes.
you have it.
Yes. Permit, county, water, sewer, the whole 9 yards.
Well, look, some of the issues you've raised are issues that are beyond the scope of this hearing. They're issues between you and people who might
Right.
have lied to you or defrauded
Right,
you.
true.
And I'll say it's not the first time I've heard of it happening
Yes,
here in
it-
Citrus County.
yes.
Now, what the county's basically said is, look, you're allowed to have fence
Yes.
on this property,
Yes.
but before you get a principal use established, you really can't do anything else. You're not allowed to store stuff there. You're not allowed to, so basically what I'm saying is the county has presented a case that there's still a violation. Any containers or storage that you have on the property,
Yeah.
it's all got to be moved until you put that site built.
Even though I've paid taxes on
Has
all
nothing
this.
to do with whether it's in violation
Well,
of this code.
Okay, so that's gonna be between me and the tax people. That's for y'all too, though.
Not me.
Well, I
No.
mean, the county, because
Yeah.
I pay taxes on something that says,
And
I can't
I
be
don't know
there.
anything about, I don't know who the taxes are for. I don't know what the taxes are for. My job is to enforce this code,
okay,
whether we like it or not.
Excuse me one moment. He came in.
Ma'am, do you have a microphone?
Yes, sir.
Can you use the microphone, please?
no, it's not working. Come on. Okay, come on.
Oh, no,
It's fine.
It's not working? It's on.
When we first acquired the property, my husband did come up here many countless times and left frustrated. He does have a name of a person who told us things that you would not believe what county employees told us to do.
Okay.
I told them about the horses, and their answer was, they happened to be a well on there. There's been a place there, there's a well. I found this well, and I was going to try to apply for power to water the horses and the donkeys.
On this property?
Yes.
But you
And-
can't do that either
Yeah,
without
they told me, but they said, well, maybe you need to get a generator or solar, or maybe you can borrow it from the neighbors.
Okay.
You know, I don't understand how you get billed or taxed for something that ain't allowed to be there, but yet it's been there 2 years and y'all don't know about it? I mean, I'm just asking questions. And like I said, all this
Code
was,
compliance doesn't get involved until there's a complaint. That's
Okay.
essentially the law.
yeah, and I know who, yeah, the complaint, there you go.
Well, you've been here and you've heard that's how
Yes.
these cases go.
Yeah.
Excuse me, Joe, show them the card of the person where you had first come in.
Is she talking to you or to me?
She's talking to me, but
Okay.
it's addressing, to show you the card of the person I talked to up here 2 years ago.
You can if you want.
mean,
I don't know if it'll make a
it's gonna do
difference.
any go, and there's the tax papers showing where the taxes went up from
I'll take a
nothing
look.
to everything.
I'll take a look.
It shows each building individually.
Ma'am, I really need you to use the microphone. It does work.
Can you hear me?
Yes, that's much
Okay.
better.
On that tax paper, it shows each individually and a price.
Okay.
And we paid.
So with
Again,
that,
it
we
won't have
assumed
anything to
that it
do with
was-
this case, but I do want to see it to understand where
Well,
you're
you
coming
can
from.
imagine how confusing that is to
Yeah,
us.
you get a document paying for something, but you're telling me I can't have it.
Yeah, I am going to say you can't have it without the site-built home.
Okay.
Does the county have any objection to me reviewing this?
No objection.
Thanks. Okay, yeah. The way this works is you might report all kinds of things that get reflected on the property, but it doesn't mean that everyone, code compliance doesn't read,
Okay.
just, it doesn't like come to them and they read the many thousands and
Yeah.
thousands and thousands.
Right.
They don't do that. They function based on complaints.
Okay.
And so once it's raised, in fact, I've had cases where things that were from 1989.
Okay.
I mean, I'm just letting you know. So I have to apply the law based, I'm gonna introduce this
Okay,
as
thank you.
Exhibit 1 on your behalf.
Thank
If you want to appeal this, it'll be a part of the record.
Okay.
And I'll introduce the card as Exhibit 2. I'll represent for the record that it's for Lynette Ferdinand.
Yes.
Okay. And
She's the one that told me about, oh, you can put a generator to water the animals,
okay.
so.
Um,
But the mobile home has been took care of, moved,
it has
and that's what drawed,
the attention.
right, correct.
Well, but now you've heard, it's gonna
Yes.
take more than that to get rid of the violation.
Okay.
What's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 per day, along with the administrative costs to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. We would also ask the special master additionally to find that it is the respondent's responsibility to contact Code Compliance Division when the violation has been abated in order to allow for reinspection.
How much time would you need to bring the property into
Well,
compliance?
considering that we're gonna start the process of, when I got notified as yesterday,
And do,
120 days, 3 or 4 months. The big problem for me,
excuse me, can I say something? My chemo will be 3 months, then I'll be 3 weeks after, and then I'll start radiation for a month. So please allow us to get through that.
a good bit of time, sir. Whatever you can grant us would be appreciated.
Okay, you do understand what it takes?
Yes, it's gonna take a lot.
Okay. To the best of your knowledge, what's on the property that needs to be removed?
There's a barn, there's several carports, there's a bunch of vehicles, horse trailers, some campers.
One question about the carport, that was on there before the property was purchased.
It's irrelevant.
And it was, the county has notification on it.
Again, it's irrelevant. If you buy a piece of property, for example, that has a house that hasn't been permitted at all,
Okay.
beautiful house, it doesn't mean that it's not in violation of the county code or that the buyer isn't responsible for it under the code. And that's why inspections are necessary, and it's why sellers are supposed to, if it's done at a regular closing, certify that there's nothing wrong with the property, there's nothing unpermitted. People don't always do that, but it does put the responsibility, unfortunately, on the buyer if it's done
Okay.
wrong.
Well, being said that, it's gonna take a great deal of time.
Yeah, okay, so I'm gonna find the property is in violation, grant 6 months to abate the violations. If it's not brought into compliance in 6 months, then a fine of $50 a day will accrue. Okay? 6 months.
Okay.
Good luck.
And they'll be welcome to visit the property as we make progress.
They'll appreciate that.
Okay.
They don't get that from all the owners.
Okay, thank you. All right, thank you.
Next case on today's agenda, Willie James and Shirley A. Booth. Case number 2023-00685, Code Officer Alan Jonason, page 10 of your agenda.
Are there any cases on this agenda that have abated that we won't be hearing?
All the ones that are listed out.
No, I'm just, last hearing, we had one that we didn't end up hearing because it abated. I'm just curious if there's, not this time. Okay, thanks.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Yes. Your names, please?
I'm Vanessa Thomas. I'm with the law firm of Foreman and Thomas, 1301 Northeast 14th Street, Ocala, Florida, 34470.
Okay, great.
Janice Booth Tootin, 2355 North Florida Avenue, Hernando, Florida, representing my mom and dad, Willie and Shirley Booth.
Now, ma'am, I just want to make sure, so you're here retained on behalf of the owners?
Yes, I am.
Okay.
Well, on behalf of Mr. Booth, Ms. Booth just recently passed.
Okay, all right. And is, to the best of your knowledge, is he now the sole owner, or was it jointly?
Yes.
Okay, all right. Please proceed.
Good morning.
Good morning.
Alan Jonason, Citrus County Code Compliance Officer. This is case number 202300685, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. The address of the violation is 2355 North Florida Avenue, Hernando, Florida. Property owners are Booth Willie James and Booth Shirley A. I have good service via posting the notice of hearing on the property and posting at the Lecanto Government Building. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during my initial inspection on 16 August 2023, photos from my compliance inspection on 25 September 2023, and photos of my final inspection conducted on 14 November 2023. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the posting affidavit, a photo of the notice of hearing posted on the property, and a copy of the pre-hearing order.
Okay, ma'ams, I'd like to ask you to take a look. By the way, it's nice to finally meet you in person.
Nice to meet you.
Please take a look at these documents and let me know if you have any objection to them.
16. That makes sense. Yep. So we have here, yep.
I think we'll take a 5-minute break after this case.
16. 25. There you go. Violation, yeah, that's that. Okay. We have no objection.
Okay. Okay, without objection, what's been proposed as exhibits A and B are evidence.
On 16 August 2023, I conducted my initial inspection and observed the property to be in violation. On 16 August 2023, a notice of violation was issued for junkyard conditions, which is a violation of the ordinance mentioned earlier. On 25 September 2023, I conducted a compliance inspection and observed that the property remained in violation. I've had brief contact with the property owner's daughter, and as of my final inspection on 14 November 2023, the property remains in violation.
Well, first of all, ma'am, I'm sorry for your loss. I mean, I know what that's like. What would y'all like to say?
As you can tell from the photos from the 16th to the 25th, there wasn't a whole lot of change, but from the 25th to the 14th, there has been. They had to get people in place to do this.
Her father is quite elderly. He can't do anything. It's on her to try to help them.
Yeah.
Mom was in end-of-life care.
Yeah.
So that had, it just eats up a lot of her time.
There's
She
huge
has-
improvement, like
Yeah,
you said.
she's been making, and she intends to continue and get it abated. She just really needs some more time.
How much time?
Well, we've got the holidays. She's got some people that are gonna have to come in and haul away junk.
It doesn't look that bad compared to what it was, and from what I see.
It's an improvement.
Yeah.
But they do wanna, bring it in compliance and get it, shaped up. She's probably, we've got the holidays here, so she's probably gonna need till the end of January, I'm guessing.
Okay.
When you think?
Okay.
Most likely, she'll need till the end of January.
What's the county's recommendation on
The
this?
Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 per day along with the administrative cost to begin after the date you deem sufficient to abate the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to the violation. We would also ask the special master additionally find that it is the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
Yeah, certainly based on the improvement that's already been made, the good faith, the extenuating circumstances, I think until the end of January is reasonable. So I'll find that the property is in violation. Oh, I'm sorry. Is there anyone from the public who wants to be heard on this case? I don't see any. Does anyone else? Okay. I'll grant 75 days from today to abate. That takes till the end of, till the end of January.
Yeah.
Almost exactly. All right. And if it's not brought into compliance as ordered, a fine of $50 per day.
Okay, Your Honor.
All right.
Thank you.
Thank you.
Thank you.
Next case, Dayco
We're
Truck.
gonna do a 5-minute
Oh,
break.
sorry.
All right, so the time is 10:43-ish. We'll come back at 10:48. Okay. Time is actually a little later than I said we'd get back. It's 10:50, and we're back on the record.
Next case is on today's agenda, Jeremy and Berlissa Bayless, case numbers 2023-595 and 2023-659. Code Officer Brandon Norman, page 7 and 8 of your agenda.
And is there anyone from the public who's going to want to be heard on any of these cases? All right, I don't see any response.
Good morning, Brandon Norman, Citrus County Code Compliance Officer. This is for case number 2023-00595, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances, and 2023-00659, abandoned, unserviceable, and unlicensed vehicles, a violation of Chapter 20, Article 4, Section 20-41 of the Citrus County Code of Ordinances. The address listed is 10207 East Pike Drive in Inverness, Florida, 34450. Property owners listed as Jeremy and Berlissa Bailu. I have good service via posting at the property in the Lecanto Government Building, and I would like to authenticate the following documents requested be admitted into evidence. Both sets of exhibits, the photos were taken on the same days.
Okay.
Exhibit A will be photos taken during the initial inspection on August 7th, 2023, the corrective action inspection on September 12th, 2023, and the final inspection done yesterday, November 14th, 2023. Exhibit B for both cases will be a copy of the notice of violation, a copy of the notice of hearing, a copy of the pre-hearing order, a copy of the posting affidavits that completed, and photos of the posted notices of hearing at the property.
Okay, let the record reflect there's no objection to either of the sets of evidence. So they're both admitted as exhibits A and B in each case.
On August 7th, 2023, an initial inspection was conducted of the property for junk and debris. The property was found to be in violation for junk and debris and unlicensed and unserviceable vehicles. The property remained in violation of my notice of violation corrective action inspection that I did on September 12th, 2023, as well as my pre-hearing inspection that I did yesterday, November 14th, 2023. I have made contact with someone who identified themselves as the occupant of the home. I made them aware of the violation, how to bring it into compliance. There has been some progress made, but violations still remain.
I do think the photos essentially speak for themselves. What's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $100 per day, along with administrative costs for each case to begin after the date that you deem sufficient to abate these violations. This amount was selected based on the actions of the property owners once they revised the violation. This amount is appropriate given the severity of the violations and the respondent's actions relative to these violations. We would also ask that the special master find its respondent's responsibility to contact the Code Compliance Division when the violations have been abated in order to allow for reinspection.
Okay, in each case, I do adopt the county's proposed findings of fact. The property is in violation in each case. I'll grant 30 days to bring it into compliance in each case, and if it's not brought into compliance, a fine of $100 per day will accrue.
Thank you.
Thanks.
Next case on today's agenda, Daco Trust, case number 2023-672. Code Officer Amy Becker, page 14 of your agenda. Expert on the case, Land Development Director Joanna Coutu.
Sir? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Can you please state, excuse me, can you please state your name?
Ricky Allen Johnson.
Thank you, sir.
Thank you. And Mr. Johnson, are you a trustee of the trust?
No, he's the trustee.
Okay, there is a trustee here. Are you an agent of the trustee? So there's people who have standing to represent owners. There's people who have, I just need to know your relationship. Are you a
buying.
tenant?
Yes, I'm buying.
You're buying?
Yes.
Okay, you're under contract to buy the property?
Yes.
All right, and trustee, Sir, you're the seller?
Yes.
Okay, and what's your name?
DJ, Jim Paul, Jim John, Barry, B-A-R-R-Y.
And you're trustee of the DACO?
Diego Bowling. Diego Bowling.
Okay, gotcha. Okay, please proceed.
Good morning.
Good morning.
Amy Becker, Citrus County Code Compliance Officer. This is case number 23-672, a violation of the Citrus County Land Development Code, Section 3210, animal pens and similar structures in residential zoning districts. The address is 2160 West Beaumont Lane, Lecanto, Florida. The property owner is Daco Trust. I have good service via signed certified mail return receipt. And I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during my initial inspection on August 17th, 2023. Photos taken on August 21st, 2023. Photo taken on August 4th, 2023.
No, September 4th?
August,
Okay.
August 17th, 2023 was the first one, and then August 21st, 2023, and then October 4th.
Oh, October 4th. I thought you said August.
October
Gotcha.
4th, 2023. And the photos taken on my final inspection, November 14th. Exhibit B is a copy of the notice of violation, a copy of the notice of hearing and pre-hearing order, and a copy of the signed certified mail return receipt signed for on October 13th, 2023. Exhibit C, an aerial view of the property from the Citrus County property appraiser.
Okay. Sir, I'd like to ask, sirs, really, I'd like to ask you to take a look at these documents and let me know if you have any objection to them. I mean, sir, frankly, as the buyer, if you're not the owner, I don't think you have any standing, but, yeah. Sir, I'd like you to sit if you would like to sit. Okay.
Huh? Yeah, that's not there anymore, so. See, somebody went back there. Hmm? Mhm. I have no problem with it, except for this one. This one's not.
What about that photo?
This one is it's not relevant anymore. I took care of that problem.
Okay, well, I mean, but do you see the date on it?
Yes.
Was it there on that date?
Yes.
Okay, so do you believe that photo is wrong or inauthentic or?
No, that's right. but
It's a real photo?
It's a real.
Okay, all right, then I'm gonna overrule the objection. But I'll let you talk about it. I mean, I wanna hear what you have to say about it. Are you already in possession of the property?
Yeah, I live there.
So even though you haven't completed the purchase, you are in possession?
Yes.
Okay. Oh, are there people from the public who want to speak on this? I see one. Is there more than one? All right.
Who's that?
Okay. There was an objection. I've overruled it, and otherwise, exhibits A and B are admitted as evidence.
On August 17th, 2023, I conducted my initial inspection and observed dog pens near the back of the property. I spoke with Ricky Johnson and was told that they don't sell the dogs, that they're his dogs. I advised him per the Land Development Code that the kennels must be a certain distance from the property line. I gave him the website for Citrus County so we could get the information. I was denied access at that time to go onto the property. On August 21st, 2023, there was an inspection done with animal control and a code compliance officer. Approximately 10 kennels were observed, basically 8 feet from the property line, 12 feet from the side. The larger kennels, yes, they were approximately 8 feet from the property line. And then on October 4th, another inspection, it failed. The dog kennels were not moved. I spoke with Ricky via cell phone. I gave the person at the house, her name was Lisa, the notice of violation. On October 24th, I received a voicemail from PJ advising he received the certified mail, left a contact phone. I advised him of the violation. As of my inspection on November 14th, the kennels have not been moved. They need to be 50 feet from the property line. I gave you a reference as far as the
And
aerial.
there's a fence now to try and block you from seeing?
I'm assuming that's what the, I mean, I don't want to make an
I
assumption.
mean, it looks good.
But anyway, you get the idea. I have an expert witness, Joanna Katu.
Yeah, great.
The site is 1 acre. It's low density residential, so it does qualify as a residential district. It needs the 50-foot setback.
It needs, these kennels need a 50-foot setback.
Right, and she cited the correct 3210. That's correct.
Okay. Let me just look at this. So I've never seen this code section.
Unusual. Let's see it too often.
Hmm. 50 feet's gonna be difficult to pull off on this one.
Yes, it'll be on top of my well or my swimming pool.
Right.
And no one lives behind me.
Wow. Okay. So what's your perspective on this?
My perspective on this is I didn't know about the setbacks. I know about setbacks in the front of the house is 50 feet, but I didn't know about setbacks in the front of the house. I thought it was like six feet from your property line that you have to have access to. And I don't have domestic dogs. I have working dogs.
So what does that mean?
I have coonhound curs. They're hunting dogs. And I have broad jump dogs and dogs that climb the wall and pull and tug.
Wow. All right, let me review this code section.
And you know, people have chicken coops next to it on the property line, but
Stable, barn,
Hmm?
hutch, pen, shed, or other such structure built to contain dogs and or cats shall be not less than 50 feet from any property line, unless it's 10 or more acres in certain zonings.
and I keep it clean back there. Health control came past. They canceled that case because I keep it excellent clean back there. I'm OCD. I cannot have that.
Is it possible, look, the property is in violation, but what I'm interested in is how to fix it. So is it possible to apply for a variance on something like this? I mean, I'm without regard to their chances of being granted.
Right, that would be the one thing, is demonstrating a hardship.
Mhm.
Yes, there is a I haven't had anybody try. I have to take a look at it.
Yeah,
and
I
think
don't know
about it.
either. Okay.
Yeah, it's more of a conditional, I don't know. I would,
Yeah, well, whether it was a variance or some kind of other
Right.
special exception or something, I don't know. Conditional use permit,
And
whatever
de-
you want to call it.
and demonstrating the hardship that this lot needs to have this, to be a residential.
And I don't know if they could. I guess one factor that I could imagine being taken into account is the lack of an inhabited lot behind it. I don't know.
Perhaps,
I don't
but
know.
it's a residential zoning and has a house, so we've shown it. can
Well, like
be
I
a
said, I think
residence.
there's a violation. I'm just
Yeah.
trying to figure out how much
No,
time.
I'm reasoning too. Yeah, I don't think his chances are very good. If we went forward with this, he can apply for it. That would be about 3 months.
Okay. Hey.
I'm Officer Gaunt with the Citrus County Sheriff's Office Animal Control Unit.
Okay.
So I dealt with Mr. Johnson. Just so you know, the county ordinance states that each kennel has to be 80 square feet per dog. He was in violation of the smell. We've had multiple complaints of the barking dogs.
The smell?
Yes, sir.
So what does that mean?
The feces coming from the pens being
There's
flushed
a
out.
code section on this. So like the smell can't travel or.
It can't travel to a certain extent. I mean, you got 20-something dogs
Mhm.
that
I have 10.
now, you might have 10 now. I have not been on the property in a while. But when you're washing the pins out, the feces go on the ground. It's not going into a septic tank. It's not going anywhere but laying on top of the ground.
Okay, and I presume that's probably why it says 50 feet setback in the code section. Okay. Is there anything else you'd like to offer?
I haven't been able to make contact with him except today.
Okay. Was there someone from the public who wanted to be heard?
I clean that every day.
Okay. I would like to hear from the public. Yeah. And so, did you swear an oath?
Yes.
Oh, you did. Okay.
Oh, I will.
No, I don't. I don't remember you doing it. So yeah.
Let's do the officer go on first. Well, I could do
Both of you. You can do both.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes,
I know you're.
No, sir. Do you swear and affirm that everything you just said was the truth? Okay. All right.
Sir, your name?
My name is Andrew Peterson.
Thank you.
I'm a resident of Timberlane. I'm also the president of the Timberlane Homeowners Association.
Okay. And is this property subject to that HOA?
It is.
Okay.
I'm here speaking on behalf of the residents of Timberlane.
Okay.
With regard to, and that gentleman, we've never met. The property in question that was brought to my attention, I was the complainant.
Mhm.
There are neighbors to the east, to the west immediately, and there's, the lot behind is vacant, but there's a lot inhabited that touches the corner.
Okay.
I've been in touch with all those residents. They asked me to file a complaint for code compliance.
Debbie asked you to?
Sir, if you don't mind, we're going to hear from the public. Thank you.
And so with that, I was the original complainant and also filed the complaint with animal control. That's part of my job, and part of my job is to come here and speak as well. So as you said, they are in violation. The other residents, they're not here to testify or speak, but I can tell you they're not in favor of a variance if there was one to be had. They have complained to me about the smell as well. My point to being here is to ensure compliance. and to speak to you with regard to any time limits that you may give. So the first structures that went up were the kennels themselves. Since then, you saw the fence, nice fence, no issue with that, as long as it's permitted in course with the code compliance. And the shed was also erected on the property line with the vacant lot. No issue with that as long as it's permitted in code compliance. There was debris from the fence that was deposited on that vacant lot. I had pictures of that. I went to the neighbors. So there was construction debris. It was recent that has since been removed. So that doesn't appear to be an issue either. With regard to coming into compliance, any timeframes that might be requested. Like I said, the kennels were built first. Notice was that they were in compliance. The time it took to build that fence and erect the shed could have been used to dismantle those kennels and come into compliance with the code. That's my point. So the time has been there to do this. It has not been enacted. So when considering a time limit to come into compliance, please take that into consideration. So there was ample time to do it. Construction was, there's no mitigating circumstances that physical or otherwise that would prevent them from doing it. And also very important when the county asked for their, when their compliance is that the residents notify the county of its, pardon me, of its completion or coming into compliance because of the fence, right? Because once that fence is erected, I know county limitations about eavesdropping and, I could fly my drone over, but, they can't do this, so taking pictures of the fence. So please take that into consideration as well. So the amount of time taken to come to compliance and the recent activities may stymie the county's efforts.
Okay. Thank you.
Yeah.
Is there anyone else from the public who wants to be heard? All right, now, sir, I would like to invite you. You can respond to anything you heard if you'd like.
I'm just, oh God. It doesn't smell. My dogs were in new spots. They bark. They no longer bark. Not even at the coyote or the turtle, or they don't bark anymore. They're just the quiet, the docile, except when it's time to eat.
Well, what would you say to the point that, there was notice issued 3 months ago, essentially, and
I didn't get that notice until
I'm not done.
sorry.
Notice was issued essentially 3 months ago, and the first photos were taken 3 months ago. Let me put it that way, and nothing. Do you not believe there's a violation in terms of the setback? Do you want me to find that there's not a violation?
the setback. I thought it was off the front of the house,
Right.
Not the rear of the house.
Right.
Maybe I was ignorant to the fact. I don't know. I would like to know. You know what I'm saying? Because I thought it was only 8 feet, and
Yeah, it says 50 feet. So, but I guess what I was wondering, do you not believe it's in violation? Is that why you haven't done anything about it?
I haven't had the funds to
Okay.
do anything about it just yet.
Well, again, the point was raised that there was a fence and some other things
Yeah.
taken, and so I don't know if those were free or not, but, why do the effort to do that and not actually fix the violation?
To move a whole 50-foot slab is like, ugh.
Is there a slab under there?
Yes, yes, sir. And we have a permit after the fact that should be coming anytime. That I have a permit for that now, for the slab.
Well, tell me about that. So, are you saying you do have a permit for the slab?
No, it should be coming any day. Because I put it in last Wednesday, maybe Tuesday.
Has do you know if code compliance has a case regarding the slab?
I don't know, but I was just trying to yes, get everything in order. Same as I did with animal control, building the big boxes and everything. That I since got rid of the small boxes that they said was couldn't have those, so I got the big boxes, and they're 80 by the big.
Well, if you hadn't brought it up, you maybe would have gotten that after the fact permit. I don't know. I don't know what the county's going to do now. Is the county aware of an application for an after the fact permit regarding the slab? I'm just asking if you're aware.
He spoke with Tim Williams, the licensing officer, regarding
Who I
the
met
permit,
earlier.
but he is not, there's no permit issued, and in other words, in order to get that permit, if hypothetically, he would have to remove all that caging, all those kennels would have to be removed from the slab. And I also.
In order to get the permit?
In order to get the permit, all those kennels would have to be removed.
Why?
Because it would just be for the slab. The kennels have to be 50 feet from the property line.
No, I know that, but but in order to get the permit,
In order to get the permit for the slab,
yeah.
the kennels would have to be removed. It would just be a permit for a slab.
Mm-hmm.
And then the permit for the shed, I notified Tim Williams with licensing for the permit for the shed. He'll need a permit for that as well. And I notified Ricky Johnson on August 4th. I confirmed and gave Lisa a copy of the notice of violation
Right.
as far as the 50 feet.
Well, look, there's a violation here. It says 50 feet. I understand the hardship, but how long is it going to take to fix?
4 to 6 months, I guess.
To move the, I mean, these look like,
Because I got to build more boxes and everything.
Pens have to be on slab, don't
No.
they? No?
it's interesting. Let me just take a look at this.
It has to be solid, it's not the ground, it has to be a solid surface.
What's the
Not dirt.
difference?
It has to be either
Wood or.
wood or
Yeah.
cement.
It can be on the dirt.
I'm not,
I mean, what's the difference? Ease of cleaning or?
I'm not putting my dogs on no dirt.
It's more easier to clean.
Okay.
Better for the animal.
These don't look like complicated structures, honestly.
Just costs a lot of money.
Unfortunately, this is a lot of the cases we get, and you've heard some of the after the fact permit cases.
Yes.
They're essentially, in my opinion, victimless in that, if there's a carport, the only potential victims are the people who live there if it's an unsafe structure. Or maybe it's hideous and ugly, although nothing I've seen today has been hideous and ugly that would lower the value of people's homes. There has been some testimony here that I can tell you love those dogs, but there is some testimony that it bothers people. And so I hesitate to call them victims, but if the smell is affecting people.
I'm pretty sure he didn't talk to Debbie.
Well,
And that's my neighbor too.
Yeah.
Who's closest to this.
Right.
And she has dogs also,
Yeah.
And no problem.
But my point is, this is something that there is a ground to, I think, get it taken care of sooner rather than later. I do understand the money point. What's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $150 per day, along with administrative costs, begin after the date you deem sufficient to abate this violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. We would also ask that the special master additionally find that it's the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
150. Everybody else got 50.
All right, I'm gonna find that the property is in violation. I'm gonna grant 4 months to get this thing done. And if it's not brought into compliance as ordered, what was the county recommendation?
150.
$150 per day. Okay? That's it. Good luck.
Okay, thank you.
Next case is on today's agenda. Shelley Muffley, case number 2023-921 and 2023-922. Code Officer Amy Becker, pages 25 and 26 of your agenda.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Please state your name.
My name is George Muffley.
Thank you.
Good morning.
Good morning, everyone.
I'm assuming you want these at the same time.
Unless you have an objection, I usually, if there's two cases, I like them to be presented at the same
It's
time.
fine, whenever you need.
No problem.
Okay, then go ahead.
Okay, so this is case number 23-921, accumulation of junk and debris, a violation of the Citrus County Code of Ordinances, Chapter 20, Article 3, Section 20-31A, and case number 23-922, abandoned, unserviceable, and unlicensed vehicles, a violation of the Citrus County Code of Ordinances, Chapter 20, Article 4, Section 20-41. The address is 2664 West Faro Court, Lecanto, Florida. The property owner is Shelley Muffley. I have good service via posting of the property as well as the Lecanto Government Complex. I would like to authenticate the following documents and request that they be admitted into evidence for both cases. Exhibit A, photos taken during my initial inspection on October 4th, 2023. Photos taken on October 19th at my corrective action inspection. Photos taken on October 31st, 2023, showing the posting of the property, and photos taken on my final inspection, November 14th, 2023. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing and pre-hearing orders, and a copy of the posting affidavits for both cases.
Okay, so sir, I'd like to ask you to take a look at these documents and let me know,
Okay.
if you have any objection to them. Does code compliance have any policies regarding like Christmas pardons? Do you ever issue?
Yes, we're against it.
No? No? No policy on Christmas pardons?
What does that mean?
Maybe no demolitions on Christmas Day.
Yeah.
Yeah.
When I was a prosecutor, I issued
Yes,
Christmas
ma'am.
pardons on certain charges. Yeah.
This is the vehicles.
Okay.
I'll get that.
Well, we're gonna be here for a couple hours. Yeah, but we're gonna try and take y'all's cases first, if you're here in person. So I don't know what order they've got it in. I'm gonna try and get everyone out of here by noon. And I'll keep code compliance here for all the cases where people didn't show up. I mean, it depends on how hard people fight, I mean, if they contest and they have a good case, we could be here for a while. Okay, all right, well, then maybe we need to get them up real soon. Okay, all right, are there any objections to these exhibits? Legal objections?
No, sir, I guess not. The only thing is with that one mobile home, my camper, I moved here over a year ago and I noticed that the tags are dead.
Mhm.
I plan on just leaving it there on the property, so I was unaware of that you had to, if you have to have tags here in Florida, you have to have insurance. I'm wondering how that works because I'm on a fixed income and I'm not gonna be able to put insurance on something and I'm not driving on the road, so
Okay.
that doesn't make sense to me.
I
So
hear
I would
you.
like to understand what I could do to correct that.
All right, we'll get to that then. So I don't construe that as an objection to the evidence, to
Okay,
the
yeah, I have
photos.
no objection.
All right, then I'll
I've taken care of a
admit,
lot of it.
I'll admit exhibits A and B in each case as evidence, and Ms. Becker, please proceed.
On October 4th, 2023, I conducted my initial inspection as far as the vehicles and observed one trailer. I was unable to view the tag. There was a yellow Dodge with no tag, a boat with no tag, trailer and a boat with no tag, a Dodge SUV with no plate, a Jayco camper expired, 2 campers on the left side where I was unable to view the plate, a Suzuki pickup, I was unable to view the plate. And then as far as junkyard conditions, there was auto parts and other debris. And I'm going to skip forward in essence of time because he has done a fantastic job of working on this property. The progress made is tremendous. I closed the lawn complaint.
Okay.
And as far as the junk, he's almost got it completed.
Yep.
It's 1 truckload and a couple of bags, and he's working on the back deck. You can see it on the last picture. And as far as the vehicles, he's got, he's going to keep the black trailer and
Yes, ma'am,
and
yes.
he's going to get rid of 2 campers. He's working on everything, I guess is the main point.
Yeah.
And I'm thinking he's going to be able to reach compliance.
Yeah, I think so too. All right, so sir, regarding your question, I can't advise you on how to proceed. All I can say is, here's what the law says here. It shall be a violation for any person to keep, dump, store, place, or deposit abandoned, unlicensed, inoperable, junked, disabled, wrecked, discarded, or otherwise unused vehicles on the property. So it does have to be registered under this code section.
Can it be put behind the fence where no one can see it?
That's not what it says here. It says that you can't have those there. It doesn't say keep them out of view. It's not like trash, in other words. With trash, if you put it in a receptacle or you keep it in your
Right,
house.
that's why I asked that question.
No, it's a good question. That's not what the code says. So what I need to know in each case, and it looks like you're really, really close on junkyard conditions. I don't think that'll take you much time.
I have everything cleaned already, sir. It's just in my truck. I have to go to
Right,
the dump.
right,
I didn't
right,
go because it was raining yesterday.
Fair enough.
Or it would have been gone.
So your problem is the unlicensed vehicles.
Yeah, I'm gonna have only just my one black camper that I tow behind my truck. Like I said, I don't have the money for the insurance on those, so. And my camper's never gonna be back out on the road. I moved it here from Maryland. I plan on just keeping it there for guests that come to my
Sure.
house.
Yeah. You did plan on that.
Yep.
Yeah, okay, okay. Now, how much time will it take you to fix this vehicle issue?
I'd like to get 90 days if I could, because
Okay,
I'm gonna
what's
have to get those removed.
What's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 per day per violation, along with administrative costs to begin after the date you deem sufficient to abate these violations. This amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. We would also ask that the special master additionally find that it's the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
Okay, on each property, I will find it in violation. In the junkyard conditions case, I'll grant 30 days from today to abate the violation, just because of the good faith and how far they've come, or excuse me, Mr. Muffley, you've come in getting here. And then I'll grant 90 days on the unlicensed vehicle case. In each case, if it's not brought into compliance as ordered, a fine of $50 per day.
That sounds wonderful.
Okay,
Thank you,
good
sir.
luck.
Next case is on today's agenda, Matthew DiGiacomo, hope I'm pronouncing that right. Case number 2023-410 and 2023-411, Code Officer Cody McGuire, pages 15 and 16 of your agenda.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you, sir.
And what's your name, sir?
Matthew DiGiacomo.
You're the owner.
Yeah.
All right.
Would you like them done together?
Yes, please.
Okay. Cody McGuire, Citrus County Code Compliance Officer, case number 2023-00410, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances, and case number 2023-00411, unlicensed, inoperable vehicle, a violation of Chapter 20, Article 6, Section 20-41 of the Citrus County Code of Ordinances. Address is 7170 West Sunrise Loop, property owner DeGiacomo Matthew. Good service, posting the property and posting at the Lecanto Government Building. I would like to authenticate the following documents and request they be admitted in evidence. Exhibit A, photos taken during initial inspection on July 10th, 2023, corrective action inspection on September 11th, 2023, and photos of my final inspection conducted on November 14th, 2023. Exhibit B, a copy of the notice of violation, copy of the notice of hearing, and a copy of the posting affidavit, and a photo of the notice of hearing posted on the property in a pre-hearing order.
And this is for both cases?
Yes, sir.
All right, so sir, I heard your comment earlier, by the way, but I'd still ask you to look through these documents and let me know if you have any objection to them.
I was. Went mess, yeah. I would have had a trip few up years ago. This sickness I had was put me through the ringer. Yeah. Yeah. It looks good to me. I mean, I know what the facts are. And what are these recent? Truck tires over here by the tree. Back of the truck. I got the spare on that side. Yeah, I mean, everything looks like it was. Excuse? The notices? Oh, yeah.
Without objection, what's been proposed as Exhibits A and B in each case are admitted as evidence. Thank you. Go ahead.
Okay. On July 10th, 2023, I conducted an initial inspection and observed the property to be in violations. A notice of violation was issued for junkyard conditions and unlicensed inoperable vehicles, which are violations of the ordinance listed above. On September 11th, I conducted a corrective action inspections and observed that the property remained in violations. I have had a contact with Mr. Matthew on November 7th throughout, in which he stated he was having troubles getting the title for the pontoon boat transferred to his name, and he had a few other personal reasons. When it came to removing the junk, as of my final inspection on November 14th, the property remains in violation but has made good progress.
Are all the vehicles still
Every vehicle is registered besides the boat. The boat is having a little bit of difficulties with the title.
All right. So the boat is still unregistered?
I had the title here, and what happened was the original owner, I guess, the husband had passed. The wife couldn't find this title and had a duplicate ordered, I guess, mailed to her. I think between when she paid for it and it came in the mail, she found the original, which she turned into the boat lot where I bought it, not knowing that this one was no good with the new one. So I got the original, which is no good.
Okay.
It should have, the title should have this 16 date on it, and this one's got, whatever it was, 07. I guess is when they bought the boat, her husband. And when she bought the duplicate, it was a 16, so that's the date that I should have, but I don't.
Okay.
So
But
I've
what you're
got
saying is the
paperwork here
vote-
that I was there and did make the effort, okay? It's highlighted in pink.
No, so I just want to understand, the boat is not currently registered today?
No, I gotta get rid of it somehow.
Okay.
I wanna try to sell it so I get some money back out of it.
How much time do you need to do that?
I don't know, maybe I can put it on Craigslist, maybe, I think they keep them for like a month on there.
Okay.
And if it doesn't sell within that month, I can look and maybe, just offer to give it away if I have to, just to get rid of it.
Okay.
Or
And
take it
then-
apart and scrap it, or sell it for parts, or whatever.
Fair enough. And then on the junkyard condition case, it does, I'm just looking through the photos here. Are you still using that trampoline?
I took that apart.
You're not using it anymore?
No,
That's,
it bent, the one leg folded up underneath it from the kids jumping on so hard. It took a nosedive. But I took it apart and it's scrapyard.
I had a neighbor that had a trampoline and he would only use it if a big storm, like a big thunderstorm was coming, almost like he was daring to get struck by lightning. I love that kid. He was,
Some people will, I tell you what. Yeah, we had 3 or 4 boys out there at once, and they, you know, my grandson, he's a wild man.
how much time do you need to fix the junkyard condition case?
I thought that was, is that suitable, what I did?
What's that?
The junkyard, it's in the junkyard.
There's just a little bit of stuff that's in front of the garage.
Yeah, well, I thought we talked about that on the phone, though. The 4-wheeler, the floor jack.
Oh yeah.
I had a chair there.
Well, that was good. But
I
there's
can
a
get rid of it.
yeah. No, there's the vacuum that's behind the treehouse. I think it's on the 7th
Yeah,
photo.
I'll get all that little
There's
stuff.
just a
yeah.
little
There's
bit of
few
stuff
odds and
here.
ends, yes sir.
Yeah, there are very few odds and ends. Yeah, I don't think you need much time for that. But what I'll do is, what's the county's recommendation? And I'm sorry, is there anyone from the public who wants to be heard on this case? No, go ahead.
Okay. The Citrus County Code Compliance Division respectfully requests that the special master assesses a fine of $50 per day per violation, along with administrative costs to begin after the date you deem sufficient to abate this violation. The amount was selected based on the actions of the property owners once they were advised of the violation. We would also ask that the special master additionally find that it's a respondent's responsibility to contact the Code Compliance Division when a violation has been abated in order to allow for reinspection.
What I'm gonna do is, I'm gonna find that the property is in violation in both cases. It's really not much of a violation on the junk case, but there are some things that still
I
need
got
to
a
be
couple of
fixed.
things left,
On
yeah.
the junk case, I'll grant you 30 days from today to fix it.
I can do that.
On the vehicle, I'll give you the 60 days you requested to get that one done.
All right.
And if either of them is not brought into compliance during the time granted, $50 per day. Okay?
Sounds fair.
All right, thank you.
Yep, thank you.
Next case is on today's agenda. Diane Rigos, case number 2023-528 and case number 2023-529. Code Officer Brandon Norman.
Ma'am, you do not need to stand. We can bring a microphone to you if you wish. Yes. Yeah.
Pages 29 and 30 of your agenda.
You don't even have to see my ugly face. You could sit behind the podium if you wanted, but, okay.
Ms. Rigos, I do have to swear you in. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, ma'am.
Can we test that mic again?
Hello,
Oh,
hello,
that's great.
hello.
That's great, okay.
Oh, I'm sorry. We got our walkers
It's a
tangled
battle
here.
of the walkers. That'd be fun to watch. All right.
Brandon Norman, Citrus County Code Compliance Officer. This is for case number 2023-00528, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. The other case is for 2023-00529, abandoned, unserviceable, and unlicensed vehicles, violation of Chapter 20, Article 4, Section 20-41 of the Citrus County Code of Ordinances. This is for the address at 12323 South Gladiolus Point, Floral City, Florida 34436. Property owner listed as Diane Rigos. I have good service via signed certified mail return receipt, and I would like to authenticate the following documents and request they be admitted into evidence. For the photos, as well as the posting affidavits and everything is on the same date, so.
Okay.
For Exhibit A for both cases, photos taken during the initial inspection of July 26, 2023, the corrective action inspection on September 5th, 2023, and the final inspection done yesterday, November 14th, 2023. Exhibit B will be a copy of the notice of violation, a copy of the notice of hearing, a copy of the pre-hearing order, and a copy of the signed certified mail return receipt.
Ma'am, I'd like to ask you to take a look at these documents and
All
let
right.
me know if you have any objection to them.
No, it doesn't. Again, they missed trash last week.
You have any objection, ma'am?
No, sir.
All right, thank you. Thank you. All right, without objection, what's been proposed as exhibits A and B in each case are admitted as evidence.
On July 26, 2023, I conducted an initial inspection of the property for a complaint of junk and debris and unlicensed vehicles. The property was found to be in violation. The property remained in violation at my notice of violation corrective action inspection done on September 5th, 2023, as well as my pre-hearing inspection done yesterday, November 14th, 2023. I haven't had contact with the property owner, so I haven't been able to make them aware. But I did have good service for my notices.
I mean, the property owner's here, right?
The property owner's here.
Okay,
Mhm.
you mean you haven't had
I haven't,
contact?
until today, I haven't,
Until-
I haven't
gotcha,
had contact with her.
All right.
There's only a few things that remain. It's still in violation. Originally it was 2 cars, now it's just 1.
Yeah.
And then it's just for the trash, it just needs to be contained in the proper storage.
Okay, so do you understand the cases?
I understand. What am I supposed to do about the trash?
So
I mean, we gotta put it somewhere. We can't put it in the
ma'am, if
house.
you please direct your comments
Sorry,
to me.
sir.
The way to abate the violations here, let me read the code section so that you understand.
Okay.
It says, "It shall be unlawful for the owner or tenant of any land to permit, cause, or have thereon any accumulation of junk, debris, rubbish, and vegetative matter, except for junk stored in enclosed litter receptacles or completely enclosed buildings." So that's an option. Either the trash gets put in litter receptacles, i.e. trash cans, or it gets enclosed. You put it in the garage, close the door, that kind of thing. Unless it's junk which will not fit in standard sized litter receptacles and which is set out for no more than 48 hours for pickup, meaning you bring it to the front of the yard, it's there for trash pickup. I don't see anything like that. There might be, okay. And except for recyclable material that's put in the right recyclable stuff. And except junk stored in a lawfully established and maintained junkyard. That's not the case here. And that's it. So that's how you've got to handle it. You got to get rid of it or you got to store it appropriately. Does that make sense?
Yes. But I don't live there.
Well,
My daughter lives there and we have,
no, you have no control over your daughter?
I have no control over her fiance.
Right.
And when all this started happening, my daughter found out she has cancer and she's dying.
Okay.
And I can't get her fiance to do anything. But she did say that they'd have the car registered by the end of the week.
Okay.
I don't know. And as for the trash that you saw, they missed trash last Friday morning. No trash was taken out, so the trash that's there will be gone Friday morning.
Yeah, there's not much. I mean, I don't see a whole lot, but let me ask Mr. Norman this. Can you see from, what's that red thing? Is that like a punching bag or something? Or
Yes, it's one of the kids' toys.
Okay.
It is a punching bag.
Is that junk?
For that photo, I wasn't referencing the actual toy. There's other things that are in the photo.
I agree. I was just wondering.
Yeah,
if
the other
I
things
don't.
are-
Yeah, if it's children's toys that are meant for like outside purposes,
Okay.
I don't regulate those. But if it's like a dilapidated toy that
Okay.
is like broken, then yeah, we would.
No, it's a
All right.
punching
So-
bag.
So it sounds like it's not going to take much time. All right. I mean, is 30 days enough? It looks. I mean, let me tell you, it's
Well,
a 30-day job to me.
Yeah, the
It's a
trash will
14
be
job.
gone in
It's
the
a
morning.
14-day job.
I don't know what about those pipey things that he has there. They're supposed to get painted and go on a truck.
Well, man,
And
let me
I don't
put it
know
this
how
way.
soon he'll do
You're
that.
the owner. So under the code section, you'll be responsible if they don't take care
Yeah,
of it.
and
But let
I'm
me
on
be-
a limited income.
Is there some reason that you don't have authority to
It's
get someone
he's
to
a
go?
jerk.
Ma'am, just hold on a second.
Sorry.
Is there some reason that you don't have authority to arrange for that, like, one thing to be picked up and put in a garbage can, or, you know?
I'll talk to them.
Okay, all right. What's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 per day along with the administrative costs for the case to begin after the date that you deem sufficient to abate these violations. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given the severity of the violations and the respondent's actions relative to these violations. We would also ask that the special master find it is respondent's responsibility to contact the Code Compliance Division once the violations have been abated in order to allow for reinspection.
I think these things can be done in a matter of days, but in light of the testimony regarding cancer and other problems and the fact that we've all got Thanksgiving next week, I'll grant 30 days from today in each case to abate the violation. I do find that there's a violation. And if they're not brought into compliance as ordered, a fine of $50 per day.
Thank
Okay?
you.
Thanks.
Next case on today's agenda, Julia C. Fitzpatrick, case number 2023-546, Code Officer Brandon Norman, page 19 of your agenda.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Your name, please?
I'm Jessica Hoover. I'm the daughter of Julia Fitzpatrick. I live at the residence as well.
Okay, thanks.
Brandon Norman, Citrus County Code Compliance Officer. This is for case 2023-00546, excessive growth and accumulation of vegetation, a violation of Chapter 20, Article 6, Section 20-61 of the Citrus County Code of Ordinances. This is for address 819 Sherwood Avenue, Inverness, Florida, 34450. This is the property owner is Julia C. Fitzpatrick. I have good service via posting of the property in the Lecanto Government Building. And I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A will be photos taken during the initial inspection on July 20th, 2023, the corrective action inspection done on September 5th, 2023, and photos of my final inspection done yesterday, November 14th, 2023. Exhibit B will be a copy of the notice of violation, a copy of the notice of hearing, a copy of the pre-hearing order, a copy of the posting affidavit that I completed, as well as a photo of the posted notice of hearing at the property.
Ma'am, I would like to ask you to just take a look at these documents. You've been here long enough, so you know how it works.
Yeah. So, okay, so these are the newer ones or the older ones from July? Or never mind, I see it. Oh yeah, that's one. These are from yesterday. Okay, okay.
No objection?
Yeah.
All right. Is there anyone from public who wants to be heard on this case? No. Okay, thank you. Without objection, we've got exhibits A and B as evidence.
On July 20th, 2023, an initial inspection was conducted of the property for overgrown lawn and junk and debris. Due to a previous case for the junk and debris, I issued a citation for the junk and debris, and I found the property to be in violation for the lawn ordinance. The property remained in violation for the lawn ordinance at my notice of violation corrective action inspection on September 5th, 2023, as well as my pre-hearing inspection conducted November 14th, 2023. I haven't had contact with the property owner, but I have had, as of today, she's here, so.
Okay, what's going on, ma'am?
Well, I didn't understand some of it. I get the backyard. The front yard, well, we mowed it down and my son trimmed the trees. There is a tree that definitely needs to be taken. We are working on it, but it costs a couple, basically we're not denying it needs to be done. We just don't have the financials, so we're working on it. We just need time to collect the finance too. I don't have any objections. We have to take care of it.
All right.
In the beginning, you could see
Well, then let me understand
there's
what
some
you're
debris.
saying. You agree about the backyard.
Yeah,
Like,
it
you
needs to be
understand
taken
that.
care. We're trying to collect funds as well, because we
And-
have the tree to take care. It has to be
So
taken
in the
care of.
front yard, okay, I see what you're saying. Well, there does appear to be, I don't see any of the rulers used that they sometimes check the 18 inches, but it looks like it's over 18 inches to me. And even in the front yard, some of the
yeah,
stuff.
it's not like that right now.
In my original photos, I think I had the ruler.
It
for
probably
the front
was. At
yard
that-
I'm
portion.
talking about as the photos as of yesterday.
For the back,
Oh, it's-
yeah, that's for the backyard.
That's
There's
the
in the
backyard?
corner by the
that's
tree.
that's the actual back. I was
Okay, yeah.
given.
So in the backyard, there's an I think there's an accumulation.
Yeah,
It's
is
the
that by the
branches.
tree?
Yeah.
The corner of yeah, that's where we have to call people in and have them because the way it look, it's just. we
Is
just
there a
have-
violation in the front yard now?
Not anymore in the front
Oh,
yard.
okay. All right. So it's just the
It's
backyard.
just the
It's
backyard's
just
the
yeah, it's just the
concern.
backyard right now.
Okay. Well, how much time do you need to fix it? I know how much time you need to fix it. About an hour. So how much time do you think you need to fix it?
Huh?
I could probably cut it with a knife in an hour if
You
I
can't.
just got
That
on
has
my
to be
knees.
licensed and bonded to have that tree cut down. We have to have that whole tree cut down and have those people clear out the whole. That's our biggest problem.
You have to have a tree cut down?
Yeah, if you look at it, it's dead. It has to be cut down. That's why we can't get back in that corner. That's what we're afraid of.
It does look
It's
like it's
dead.
not in good shape.
Yeah, it's dead, and we can't get back in there because we have to get the. We're gonna hire somebody to come and do that for us. We can't do it
Help me understand why you have to cut down that tree.
because there's a bunch of dead branches from the last storm.
Why can't you move the branches?
I probably could.
No. I want to be
No.
clear because maybe I'm not understanding. Why can't
Some
you
of 'em are
move?
heavy.
I'm sorry. Hold on a second.
All right.
Why can't you move the branches without cutting the tree down?
I don't really have a. I guess they're too heavy, or they're.
No,
all
there
like
is no
dead.
explanation.
There really
I
isn't,
mean-
but I mean. I'm about-
Okay. So the violation here is that accumulation of branches. It's vegetative matter,
The only thing I have is physical. Yeah.
as
vegetation.
well as the grass and let's look at grass, kind of brush and undergrowth there, although it's not a forest, that exceeds 18 inches in height. So that's all you
You're
got to
right.
do.
You're right. You're right. I mean,
I
it's
know.
kind of physically challenging, but I mean, yes, it could be done. But we thought it would be easier to hire somebody to do it because of the well and the way the roots are grounding. But the rest of it, you're right. It's hard to get the. I mean,
I just want to be clear. You don't, unless the county has a different. You do not have to cut the tree down to
We're not.
fix
Yeah,
the
we're not,
violation.
we're not here for the tree. Yeah.
oh, okay. So that's what we were assuming it was for because of the way the roots are growing right there.
That's why I want to be absolutely clear about what
Okay.
the violation is. The violation is,
Oh.
my understanding, is the accumulation of vegetative matter, which is the branches, as well as the grass in excess of 18 inches.
Okay.
That's it. So how much time do you need to fix that, in your opinion?
I could. I mean, I could have it done in a day. You're
I
right.
agree. Yeah. All right. I'll
like-
give you more than a day. But
that would be appreciated. I mean, a couple of weeks, I can have
okay.
my kids
What's-
come and
what's-
help me.
Fair enough. What's the county's recommendation?
I mean, if that's all it was, I was assuming it was the tree.
Mm-mm.
Oh, okay.
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $150 per day along with the administrative cost to begin after the date that you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. We would also ask that the special master find that it is respondent's responsibility to contact the Code Compliance Division once the violation has been abated in order to allow for reinspection.
Y'all did a great job on the front yard. You fixed it.
Yeah, we thought we did the whole other side, but I guess that one corner kind of stuck in our, because
So-
there's really heavy branches that fell from the storm.
So what I'm gonna do is grant 14 days, 2 weeks,
Okay.
to abate the violation here.
Now that
And
I know it's not the tree, I feel much better.
Yeah, yeah.
Thank
and
you.
And if it's not brought into compliance as ordered, a fine of $150 per day.
Okay.
So, all right, thank you.
Thank you.
Next case on today's agenda, James Elder, case number 2023-561, Code Officer Amy Becker, page 17 of your agenda.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Your name, please?
James Elder.
Thank
Welcome,
you.
Mr. Elder. You're the last of the people who actually showed up for the hearing. All right. I was gonna say, maybe. All right. Please proceed.
Amy Becker, Citrus County Code Compliance Officer. This is case number 23-561, accumulation of junk and debris, a violation of the Citrus County Code of Ordinances, Chapter 20, Article 3, Section 20-31A. The address is 8459 North Tempest Drive, Citrus Springs, Florida. The property owner is James Elder. I have good service via signed certified mail return receipt. I would like to authenticate the following documents and request that they be admitted to evidence. Exhibit A, photos taken during my initial inspection on July 25th, 2023. Photos taken on October 4th, 2023. And photos taken on my final inspection, November 14th. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing and pre-hearing order, and a copy of the signed certified mail return receipt signed for on October 18th, 2023.
Sir, I'd like to ask, take a look and let me know if you have any objections. Is there anyone from the public who wants to be heard on this case?
I got newer pictures than you do. I said I got newer pictures than you do. Yeah, I was out there last night taking them. You can't see any of this anymore.
Do you have those photos with you?
Yes, yes, sir.
Okay.
Okay, I've already seen that.
All right, thanks. Well, without objection, what's been proposed as exhibits A and B will be evidence. Go ahead.
On July 25th, 2023, I conducted my initial inspection for accumulation of junk and debris and observed piles of vegetative matter approximately 5 feet high, which is a clear violation of the ordinance listed above. As of my final inspection on November 14th, the owner has installed a privacy fence. However, you can still view the violation. I have had contact with the owner. It changed hands, hence that's the date. There was a quit deed that was done, and the new owner is here today.
When did it change ownership?
August 15th is when I got the deed.
Okay. Oh, I see. So at the beginning of the case,
The notice of violation was sent to a different person.
right, but okay, all right.
It was
So-
a brother-in-law.
Gotcha. All right, well, Mr. Elder, what's going on?
Pretty much, you see what's there.
Well, I see what's there as of the time these photos were taken. You mentioned that you have photos.
Yeah, just like the one where she's got one, it's a 4-foot cattle gate, you can see the logs over
Yep.
that. I've got that blocked off now to where it's not visible and not above the 6-foot height, that's required. The one, she's got a couple pictures of the gate that I was installing. It's now have a panel behind it to where it's not visible to be seen through. So, and then a couple pictures.
Oh,
of-
you're saying it's there, it's just not visible.
No, well, no, I got a couple pictures of the area that she has of the pile of it's logs. I don't know what she considers vegetative state or whatever the terminology is, but I've got logs, but they've all been brought down, and I split wood and burn it and sell it. So
Well, look, any evidence you have, I mean,
there's the gate.
I
there's
encourage you
the-
to introduce
okay.
it so I understand what you're talking about.
Okay, just it's a cleaned up area, so you want.
Now, these are photos I'll have to keep.
That's fine. I took
Okay.
them last night. They're on my phone. So
Ms. Becker, would you mind taking a look at them? And you and Ms. Antrim or anyone from the county, let me know if you have objections to them.
No objections.
Okay. This is a residential lot.
Yes.
Okay. When were these photos taken?
last night.
All right.
Before sunset.
Okay. I mean, so I'll admit these as Exhibit 1.
Okay.
Okay. It looks like there's improvement, and it looks like you've lowered the level, but it still looks like a violation of the code section.
Okay.
Do you see why?
I mean, other than you said something about the height of the wood, but I mean, what am I?
Well, no, I'm
what
just
am I
saying it doesn't
missing?
look
Yeah.
as high as it was. It doesn't look like it's stacked as high as
Okay.
it was. But what the code section says is it's unlawful for an owner or tenant of any land to permit, cause, or have their own any accumulation of ...
Okay.
vegetative matter.
Okay.
That's an accumulation of vegetative matter.
Okay.
Does that make
So
sense?
You're just saying to reduce.
No, I'm saying you've got to eliminate it.
I'm not allowed to have a wood pile.
Well, that's a good question. Are they allowed to have wood piles?
The reason that I ran it as junkyard conditions is because of the accumulation of vegetative matter. And if you read the definition of debris, it says discarded lumber. He has a lawn company and he brings everything back and he burns it at that property. So he cannot have any vegetative matter on that property, piles of it. He's literally has a fence that is made out of vegetative matter. He
Okay.
can't, that's not
Where
a.
is I would like to see that.
It's in the definitions, if you look under the nuisance ordinance.
Yeah, that's where I'm at.
Okay, so you go to the first couple pages, and it's under the definitions, and you look at
I
debris.
mean, is that Oh, nuisance. I'm sorry.
I'm
Yeah, I was
20,
in
chapter
19.
20.
I was in 19. All right, let me look at this.
Can I say something real quick?
If you don't mind, let me read
Okay.
this because you raised a good point. Vegetative matter shall mean grass clippings, plant clippings, tree limbs, fallen trees, palm fronds, piles of leaves, none of which this is so far, and other yard debris.
But look under the definition of debris.
Okay, yeah, right.
The
Okay.
last sentence says
Right.
scrap or discarded lumber.
All right.
That's
Debris. Debris shall mean material which is stored externally exposed to the elements, so far so good for the county's case, and is not otherwise completely enclosed by a walled roofed structure, so far so good, and shall include but is not limited to the following: discarded household items, inoperative machinery, appliances, refuse, rubbish, trash, or junk, scrap or discarded lumber, pipe, steel, plastic, glass, paper, cardboard, plumbing fixtures, and other building materials. So the question is, does this constitute scrap or discarded lumber? So a pile of like wood for burning in a fire, would that violate the section?
Well, I mean, according to my interpretation,
Yeah.
which
I'm curious, yeah.
my interpretation is he's basically running a business, bringing all the stuff back to his property and burning it, and he's made a wall with wood, lumber, which is not an appropriate fence. Then he put up a privacy fence, so there's constant burning. So I get calls about the burning, and there was burning the day that I was there on November 14th. So he's basically running a business, which I did not do the notice of violation for, but essentially I did it for the junk because it is vegetative matter, it is lumber, and it is an accumulation of it. That's all I have. It falls under numerous definitions of the junk.
I mean, combustible waste material, if he's burning it.
I burn it, I sell some of it, and I also make things out of the pine logs that I bring home. I make chairs and benches and that kind of stuff out of it. So it's not like I'm,
Well, so my question, Ms. Becker, was a little different. I know you're keeping me focused on the case. It's helpful for me to understand the limits of where the code section goes, though. And so what I'm wondering is, if I have an outdoor fire pit and I've got a stack of fire logs or something there, does that violate the code section?
I would say
It's
that
combustible material. So it's rubbish, and I'm not allowed to have that next to my fire pit?
I would say that if you had a small pile, that would not be the accumulation that is on this property, on this vacant
Is
property.
there a limit on the accumulation in the definition or in your code section?
That was my vision.
You're
If you-
saying that you will enforce it in good faith and good judgment and,
there's accumulation of vegetative matter on a vacant piece of property, I'm gonna stand by it, whatever you decide.
I'm not trying to give you a hard time.
No,
I'm
no, no,
trying
no,
to-
I'm just saying.
That's a vacant piece of property.
It's vacant.
This is vacant.
Fire pit,
it's next,
that wouldn't be on a vacant piece of property.
So it's, in other words, there's
Fire
two,
pit for your own personal use, you would have a house.
Does this code section only apply to a vacant? I don't think it does.
No, it doesn't.
Applies to everything.
It only,
Yeah, so
you're
I
right.
mean, I'm not, look,
But
I,
think the point is, if you wanted to look at the code section, your wood for your fire pit should be in a container.
I think you're right. I mean, I think that's what the code section commands. I don't think that's how regular people would imagine the world works, but I think you're exactly right. All right, Mr. Elder, I do agree with the county that this is discarded lumber,
okay.
and I understand where you're coming from, but I am going to find that there's a violation. I mean,
Alright.
how much time do you need to get rid of it?
I'm not allowed to have any lumber.
You're not allowed to have an accumulation of it. I mean, what's the county's position on what he is allowed to have there?
I mean, am I allowed to have a cord of wood split? Or, I mean, a cord is 4x4x8,
Can you
There's-
help me understand what that means?
4 foot high, 4 foot wide, 8 foot long.
Is like a piece
That's all split wood, you know, like you put on your fireplace or whatever, it's all split, and it's not logs like you see in those pictures. If you see in some of those pictures, I don't know if they were the ones I took last night, there's a pile of stuff that we just split yesterday.
Yeah, I think we have to provide guidance here because,
It needs to be in a container under our code.
okay, yeah, I mean,
Or in a structure.
Okay, would a lean-to constitute that or fall under that guidelines?
This is
no,
a vacant lot.
Okay, it's not, it's a, okay, then help me figure out how this, there may not be just you, this court, but I own this is a piece of property next to my house, so they're adjoining, so.
oh, I
it's-
see. This is a vacant lot, but it's next to your house.
Yes, that I purchased.
Sure, I mean, let's introduce it.
Okay, yeah,
just so he can understand.
I'll introduce it as Exhibit C.
This is his house and that's.
Gotcha, okay. So you treat it as a unified domain,
yeah,
a kingdom in
yeah.
which,
I mean, I've
things
done
are
that
burned.
even when my brother-in-law owned it.
okay. It's interesting. I think what you've heard is right. I think the guidance is that, look, under this section, it's gotta be enclosed it's gotta be enclosed if you're going to have it there. Because
Okay.
otherwise it's an accumulation and
Okay, what is the, hypothetically, I bring something home on Friday. By the time I get it into this container, what is my guideline? I mean, 24 hours, 48 hours, does it have to be?
no, I don't see a time limit there.
I
Now,
mean-
where the time limit comes into play is when you put something out that doesn't fit in a receptacle and you put it out for trash or
Well, I'm
something,
saying like
then
if
you
I
got
bring,
48
there's,
hours.
like there's logs that I bring, if I bring them home to make something out of, they're usually
Don't bring it onto the property unless it's
But
gonna
that's
be
what I'm saying, how
enclosed.
quickly, I mean, what is that, just has to go directly in there, is that?
If you're gonna deposit, you're not allowed to have an accumulation that's not enclosed on the property.
Oh, that's what I'm saying.
So you can't
If-
dump
if
it,
I-
and then
if-
24 hours later is my interpretation of the code.
Okay.
I'm not,
No, I'm just
I-
trying, I'm trying to figure out how to to do this, to be
Yep.
in compliance and still, you know, be able to bring a log home and make something out of it and make some money, you know?
Yep.
So you're saying within 24 hours, it has to be into a
no,
container?
I'm saying immediately.
Immediately, okay. So the wood
Unless the
pile and
county
everything has to
disagrees
be-
with me.
Okay. Okay. Well, on that note, you asked me how long I'm gonna need. I'm going for back surgery right after Thanksgiving, so I'll be down for the month of December. So it's gonna be January before I could even get to it. I'd say halfway through January at least, maybe the month of January if possible.
Yeah, I mean, does the county have any outstanding or immediate health safety concerns regarding this case?
No, and he's been very civil. January is fine.
I think he's raised a good faith issue here. So what's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 per day along with administrative costs to begin after the date you deem sufficient to abate this violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. We would also ask that the special master additionally find that it's the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
All right, I will find that the property is in violation. I'll grant you 75 days till the end of January.
Okay.
And if it's not brought into compliance as ordered, a fine of $50 per day.
Okay.
All right,
Works
thank you.
for me. All right, thank you.
Next case, 20 Acres Homosassa LLC, 2023-409. Code Officer Julie Wilkinson, page 5 of your agenda. Expert on the case, Joanna Coutu.
All right, and let the record reflect, I no longer see any members of the public at all in the room, so I'm no longer going to ask if there are members of the public who wish to speak unless someone shows up. Thank you, sir. Please proceed.
Julie Wilkinson, Citrus County Code Compliance Officer, case number 2300409. A violation of Citrus County Land Development Code, section 4002, site development without a development order or permit. The address is 1360 South Suncoast Boulevard, Homosassa, Florida. Property owner is 20 Acres Homosassa LLC. I have good service via signed certified mail return receipt. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos I took during my initial inspection on July 14th, 2023. Photos from a follow-up inspection on August 7th, 2023, and aerial photos of the property from July 3rd and 20th, 2023. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the general pre-hearing order, and a copy of the signed certified mail return receipt.
All right, exhibits A and B are admitted as evidence.
I conducted my initial inspection on July 14th, 2023, and observed that the property had numerous trees removed. While researching the property, I observed that there were no permits applied for or issued. I have had contact with the property owner who stated that he was cutting down the trees to make a 50-foot fire break and that he did not need a permit to cut down the trees for that reason, which is not accurate. He also stated that he was an arborist, which he later recanted when I asked for a copy of his certification. He also stated that he has no intentions to develop the property at this time. On August 7th, 2023, I toured the property with the property owner and observed several freshly cut trees larger than 4 inches in diameter. On August 8th, 2023, a notice of violation was issued. As of November 14th, 2023, no permits have been applied for.
Is there anyone else who wishes to testify?
No, if you want to say anything.
I'm here for questions, but.
Well, I mean, I see pictures where it appears that parts of trees were cut down. And is that sufficient to constitute development if someone, let's say, cuts branches, for example,
Yes, absolutely.
and not the trunks?
I don't think it matters if any part of the tree is cut down. You shouldn't cut any trees unless you have a development order. I feel that way.
I do not.
Okay.
I don't think it's conceivable that, I'm gonna work through this. I thought this would be an easy case. And maybe it still will be, but development, when a tree is cut down, that's making room for something. Or it can affect drainage, it can affect runoff.
Yeah.
But a branch is something that can regrow. It's not irreparable. It doesn't affect, it can make way. A branch could be long enough that, by it being cut, it assists, a developer or something like that, but it's not irreparable. It'd be, with cutting off, how big a branch, if it's just a twig, a leaf, I don't buy that.
Okay.
So is there more than branches that are cut here?
Well, you can, in some of the photos, it looks like there are clusters of trees that maybe you could construe as being one tree, but I would argue that they are separate trees that are just growing very closely together. And I think there's more to consider than just erosion. There's also the eco services that these trees are providing the community, It's not just erosion,
No, but the question is development,
And the definition of development in the code, I think, will cover that.
Okay, that's yeah.
Understood that irreparable, what you're saying, that the branch can grow back, understood that.
Well, let's development. So that'll be in 1 chapter.
Yeah.
100.
Do we testify that trees greater than 4 inches in diameter were cut down?
Yes.
You
Yes.
observed that?
Yes.
You observed a tree greater than 4 inches in diameter being cut down.
Yes.
While you were
I
there?
have a photo of it in that cluster of trees.
Okay.
You can see it.
All right, just for the record, I'll read the definition of development into the record. The carrying out of any building activity or mining operation. I do not believe that it constitutes either of those if you just cut down a branch. The making of any material change in the use or appearance of any structure or land, or the dividing of land into 3 or more parcels. And certainly I've held, and I agree with the county, that clearing a property is a material change. It has to be. All right. I don't think that cutting a branch is necessarily development, but I guess it could potentially be under this definition. All right, so let me take a look again. is there a material change in the appearance if that much is cut? Maybe. Any one branch being cut down. I think, based on the amount that was cut, that probably is a material change in the appearance. Okay. I agree. Just to give some guidance on my own thinking, I think this is bare minimum development because it is, I agree with you. I think it is a material change in appearance. It may even be a material change in the use. I don't know. I don't know if the evidence is sufficient for that, but it is in terms of appearance. So what's the county's recommendation?
Due to the irreversible nature of this violation, the Citrus County Code Compliance Division respectfully requests that the special master assess a one-time fine of $2,500 along with administrative costs. This amount was selected based on the actions of the property owners once they were advised of the violation.
I'll adopt the county's proposed findings of fact and proposed fine and find it's in violation and have a fine of $2,500.
Thank you.
Next case on the day's agenda, Elizabeth G. Courtney Baker and Alan L. Boswell. Code Officer Brandon Norman, case number 2023-379, page 6 of your agenda. Expert on the case, Joanna Coutu.
Brandon Norman, Citrus County Code Compliance Officer. This is for case 202300379, special requirements for all accessory structures, a violation of Citrus County Land Development Code Section 3102A. The address is 2456 North Jungle Camp Road in Inverness, Florida 34453. Property owner listed as Elizabeth G. Baker, Courtney, and Alan L. Boswell. I have good service via signed certified mail return receipt, and I would like to authenticate the following documents and request that be admitted into evidence. Exhibit A will be photos taken during the initial inspection on July 7th, 2023, my corrective action inspection on September 21st, 2023, and my photos of my final inspection done yesterday, November 14th, 2023. Exhibit B will be a copy of the notice of violation, a copy of the notice of hearing, a copy of the pre-hearing order, and a copy of the signed certified mail return receipt.
Thank you. Exhibits A and B are evidence.
On July 7th, 2023, an initial inspection was conducted of the property for a shed on a vacant lot. The property was found to be in violation of the above ordinance. The property remained in violation of my notice of violation corrective action inspection on September 21st, 2023, as well as my pre-hearing inspection conducted November 14th, 2023. I have had no contact with the property owners. I do have an expert witness, Joanna Coutu. There is a shed on the property, but there's also other items too. So,
I mean, are you, is Coutu going to testify? Or?
I think you got the background here, but it's a residential lot, CLRMH. It's about a quarter acre. They have no adjacent property to maybe say it was part of their adjacent residence. We don't have any permits. The shed is quite old. The property appraiser references around 2005 it showed up, but without permits, it would not have been permitted on a vacant lot even at that time.
Okay, I agree. All right, what's the county's recommendation?
Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $100 per day along with administrative costs to begin after the date that you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. We would also ask that the special master find it is the respondent's responsibility to contact the Code Compliance Division once the violation has been abated in order to allow for reinspection.
Property is in violation, I'll allow 30 days. If it's not brought in compliance, $100 per day.
Thank you.
Next case, Sandra H. Baru, case number 2023-781, Code Officer Alan Jonason, page 9 of your agenda.
Alan Jonason, Citrus County Code Compliance Officer. This is case number 2023-00781, excessive growth and accumulation of vegetation, violation of Chapter 20, Article 6, Section 20-61 of the Citrus County Code of Ordinances. Address of the violation is 5715 East Live Oak Lane, Inverness, Florida. Property owner is Barubi Sandra H. I have good service via signed certified mail receipt and posting at the Lecanto Government Building. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during my initial inspection on 7 September 2023, photos from my compliance inspection on 5 October 2023, and photos from my final inspection conducted on 14 November 2023. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the signed certified mail receipt, and a copy of the pre-hearing notice.
Thank you.
Yes, sir.
Exhibits A and B are admitted as evidence.
On 7 September 2023, I conducted an initial inspection and observed the property to be in violation. On 7 September 2023, a notice of violation was issued for excessive growth and accumulation of vegetation, which is a violation of the ordinance mentioned earlier. On 5 October 2023, I conducted a compliance inspection and observed that the property remained in violation. I have not had contact with the property owner, and as of my final inspection on 14 November 2023, the property remains in violation.
Where's the violation now?
So they cut the grass, but they left the tree debris out in front of the property.
Oh, I see. You're
Yes,
talking
sir.
about the stumps
Yes, sir.
or.
Yes, sir.
I just want to look at the definitions.
Yes, sir.
I see what you're saying. It's kind of like Stonehenge. I mean, yeah, I don't know. I mean, maybe it looks decorative to me. And those, just to be clear, that's not something that's coming out of the ground.
It is not.
Yeah. Okay.
They're placed there.
There's no one here to defend it. So, what's the county's recommendation?
Yes, sir. Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 per day, along with the administrative cost to begin after the date you deem sufficient to abate the violation. This amount was selected based on the actions of the property owners once they were advised of the violation. We would also ask the special master additionally find that it is the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
Property's in violation. I'll grant 14 days to abate the violation. If it's not brought into compliance as ordered, a fine of $50 per day.
Thank you.
Yep.
Next case, Beverly A. Capio, case number 2023-586, Code Officer Brandon Norman, page 11 of your agenda.
Brandon Norman, Citrus County Co-Compliance Officer. This is for case 202300586, accumulation of junk and debris, violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. This is for address 7333 East Applewood Drive in Inverness, Florida, 34450. Property owners listed as Capo Beverly A and Capo Revocable Family Trust dated 5809. I have good service via signed certified mail return receipt, and I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A will be photos taken during the initial inspection on August 7th, 2023, the corrective action inspection on September 12th, 2023, and the final inspection on November 14th, 2023. Exhibit B will be a copy of the notice of violation, a copy of the notice of hearing, a copy of the pre-hearing order, and a copy of the signed certified mail return receipt.
Thank you. That's okay. Exhibits A and B are evidence.
On August 7th, 2023, an initial inspection was conducted at the property for junk and debris and overgrown lawn. The property was found to be in violation. The property remained in violation at my notice of violation corrective action inspection on September 12th, 2023. And as of my pre-hearing inspection conducted yesterday, November 14th, 2023, the overgrown lawn has come into compliance, but the junk and debris violations remain. I have had contact with the property owners. They are aware of the violations. They told me that it was ready for inspection, but as of yesterday, it's clear that there's still
I agree with you.
violation
What's the
present.
county's recommendation?
The Citrus County Co-Compliance Division respectfully requests that the special master assess a fine of $50 per day along with administrative costs to begin after the date that you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they revised the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. We would also ask the special master to find it as respondent's responsibility to contact the Code Compliance Division once the violations have been abated in order to allow for reinspection.
Property's in violation, 14 days, $15 a day, $50 a day if it's not brought into compliance.
Thank you.
Thanks.
Next case, Lake Oz LLC, case number 2023-745, Code Officer Julie Wilkinson, page 22 of your agenda.
You all prefer that I push through and not break for lunch, correct? Okay.
Yes, sir.
Julie Wilkinson, Citrus County Co-Compliance Officer, case number 2023-00745. Excessive growth and accumulation of vegetation, a violation of Chapter 20, Article 6, Section 20-61 of the Citrus County Code of Ordinances. The address is 6911 West Grover Cleveland Boulevard in Homosassa. Property owner is Lake Oz LLC. I have good service via signed certified mail return receipt. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos taken during an initial inspection on August 25th, 2023. Corrective action inspection on September 12th, 2023. And photos from my final inspection conducted on November 14th, 2023. And a screenshot from Google Maps Street View from 2020. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the general pre-hearing order, and a copy of the signed certified mail return receipt.
Did you take the photos on the dates indicated on the photos?
Yeah.
Okay. All right, thank you. I'm just curious, why introduce a photo from Google?
That shows that the property had been maintained within the last 5 years.
Okay. It looks like as of yesterday, according to the photos themselves, without any further testimony, that there is a violation.
Yes, sir.
What's the county's recommendation?
The Citrus County Co-Compliance Division respectfully requests that the special master assess a fine of $100 per day, along with the administrative costs, beginning after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. We would also ask that the special master additionally define that it is respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
Do you know how big the parcel is?
A little over 2 acres.
Okay. Does county want to put any other testimony on the record? I think this evidence is sufficient.
I think it is, Adam.
Okay. I'm gonna find that the property is in violation, grant 30 days to abate the violation. If it's not brought into compliance as ordered, $50 per day.
Thank you.
Thanks.
Next case, William J. Lawless, case number 2023-293, Code Officer Brandon Norman, page 23 of your agenda.
Brandon Norman, Citrus County Code Compliance Officer. This is for case 2023-00293, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. This is for address 8536 East Daniels Road, Floral City, Florida 34436. Property owner listed as William J. Lawless. I have good service via signed certified mail return receipt. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A will be photos taken during the initial inspection on June 28th, 2023, a corrective action inspection done on August 3rd, 2023, a subsequent inspection done September 14th, 2023, and the final inspection done yesterday, November 14th, 2023. Exhibit B will be a copy of the notice of violation, a copy of the notice of hearing, a copy of the pre-hearing order, and a copy of the signed certified mail return receipt.
Exhibits A and B are admitted as evidence.
On June 28th, 2023, an initial inspection was conducted of the property for junk and debris. The property was found to be in violation. The property remained in violation at my notice of violation corrective action inspection done on August 3rd, 2023, and the property owner that I met with requested additional time to come into compliance, and I obliged because there was progress made. On September 14th, 2023, as well as my pre-hearing inspection conducted yesterday, November 14th, 2023, the property remains in violation. As I stated before, I have had contact with the property owner through phone calls and also face-to-face visits with the office. He's been shown in great detail what's to be expected. Still some that needs to get done. So
I agree. What's the county's recommendation?
Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $100 per day along with the administrative costs to begin after the date that you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given the severity of the violation and respondent's actions relative to this violation. We would also ask that the special master find that it is respondent's responsibility to contact the Code Compliance Division once the violation has been abated in order to allow for reinspection.
Property's in violation. I'll grant 30 days to abate it, and if it's not, in that time, $100 per day.
Thank you.
Next case, Rhonda Lawley, case number 2023-505, Code Officer Cody McGuire, page 24 of your agenda.
Cody McGuire, Citrus County Code Compliance Officer. Case number 2023-00505, unlicensed inoperable vehicle, a violation of Chapter 20, Article 6, Section 20-41 of the Citrus County Code of Ordinances. Address is 1699 North Duran Terrace, Denellen, Florida. Property owner Lowry and Rhonda. Good service, posting of the property and posting of the Canto Government Building. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos taken during an initial inspection on July 20th, 2023, a follow-up inspection on August 8th and October 31st of 2023, a corrective action inspection on September 7th, 2023, and photos of my final inspection conducted on November 14th, 2023.
Cody, could you go over those dates slowly, please?
Yes.
I've got July 20th, August 8th, October 31st.
And September 7th.
September 7th. Okay. And is there an 11/14 or a lot of y'all?
November 14th.
November 14th. Okay.
Yes, sir.
All right. Very good. Thanks. What else?
Exhibit B, a copy of the notice of violation, copy of the notice of hearing, copy of the posting affidavit, and a photo of the notice of hearing posted on the property in a pre-hearing order.
Thank you. Exhibits A and B are evidence.
All right. On July 20th, 2023, I conducted an initial inspection and observed the property to be in violation. On July 21st, 2023, a notice of violation was issued for unlicensed vehicles, which is a violation of the ordinance listed above. On September 7th, I conducted a corrective action inspection and observed the property remained in violation. I have had contact with the residents at the property I've had contact with the residents at the property. He told me he was going to the DMV to get the vehicles
There's a
registered.
resident on the property
Yes, sir.
in this bombed out structure?
Bro, 3 days prior to me getting there, the home had burned down.
Wow. Okay.
But they admitted living in the RV to the right.
I see. Okay, gotcha. Sorry.
It's okay. The front gate has been shut, and I've had no contact ever since the first notice of violation was issued. As of my final inspection on November 14th, the property remains in violation.
What's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assesses a fine of $50 per day per violation, along with administrative costs to begin after the date you deem sufficient to abate the violation. The amount was selected based on the actions of the property owners once they were advised of the violation. We would also ask the special master additionally find that it's a respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
Is the stuff inside the burned out house considered junk now that it's not enclosed?
We have that case, we have that property also for unsafe.
I'm sure you do.
Yeah.
Nonetheless, I just want to know for the scope of the order whether you consider junk inside the house because it's no longer enclosed junk under the definition.
Well,
I would interpret it as
would
junk,
be-
yes.
It would be junk, but under the unsafe case that we have, that's all be umbrellaed under that case with because it burned.
The reason it's going to take a long time to deal with this. Have you talked to the owner about the demolition case?
So the person that I spoke to at the property does not own the property.
Right.
Okay.
And I think the owner's
Incarcerated.
in jail.
Okay. What was the county's recommended? $50 a day?
Yes, sir.
I'll find that the property's in violation, grant 120 days from today to abate the violation. If it's not brought into compliance as ordered, $50 per day. I make the time finding based on what's been represented about the owner's current position, as well as just the sheer amount of stuff that is subject to the scope of this violation. Okay.
Next case, Charles J. Ponder, case numbers 2023-856 and 2023-864. Code Officer Amy Becker, pages 27 and 28 of your agenda.
Code Officer Amy Becker, this is case number 23-856, excessive growth and accumulation of vegetation, a violation of the Citrus County Code of Ordinances, Chapter 20, Article 6, Section 20-61, and case number 23-864, accumulation of junk and debris, a violation of the Citrus County Code of Ordinances, Chapter 20, Article 3, Section 20-31A. The address is 21 Beverly Hills Boulevard, Florida. The property owner is Charles J. Ponder. I have good service via posting of the property as well as the Lecanto Government Complex for both cases. And I would like to authenticate the following documents and request that they be admitted into evidence for both cases. Exhibit A, Photos taken during my initial inspection on September 14th, 2023. Photos taken on September 29th, 2023 at my corrective action inspection. Photos taken on October 25th, 2023, showing the posting of the property, and photos taken on my final inspection, November 14th, 2023. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, and a copy of the pre-hearing order and the posting affidavit.
This is in each case, correct? Just the junk?
No, this is both.
Okay, all right. Okay.
So this is the junk.
Yeah. Thank you. Exhibits A and B are admitted in each case.
On September 14th, 2023, I conducted my initial inspection of junkyard debris and observed household items, a lampshade, discarded furniture, and other debris, and also observed that the grass was in excessive growth of 18 inches. As of my final inspection on November 14th, there's been no change. The property remains in violation for both the grass and the debris. I have not had contact with the owner. The house is vacant.
Yeah. What's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests on both cases, 864 and 856, that the special master assess a fine of $50 per day per violation, along with administrative costs to begin after the date you deem sufficient to abate this violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. And we would also ask that the special master additionally find that it's the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection
So the recommendation is 50 a day on each case?
on each violation.
Okay.
Yes, sir.
Yeah. All right. I'm going to grant 14 days on the overgrown lawn case and 30 days on the junk case. If either is not brought into compliance as ordered, then $50 a day. Thank you.
Thank you.
Next case is Richard and Joan Saya, case numbers 2023-728 and 2023-731. Code Officer Amy Becker, pages 31 and 32 of your agenda.
Amy Becker, Citrus County Code Compliance Officer. First is case number 23-728, accumulation of junk and debris, a violation of the Citrus County Code of Ordinances, Chapter 20, Article 3, Section 20-31A, and case number 23-731, abandoned, unserviceable, and unlicensed vehicles, a violation of the Citrus County Code of Ordinances, Chapter 20, Article 4, Section 20-41. I would like to, the street address is 42 South Lucille Street, Beverly Hills, Florida. The property owner is Richard Saya and Joan Saya. I have good service via signed certified mail return receipt for both. I would like to authenticate the following documents and request that they be admitted to evidence for both cases. Exhibit A, photos taken during my initial inspection on August 22nd, 2023. Photos taken on October 3rd, 2023. And photos taken on my final inspection, November 14th, 2023. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing and pre-hearing order, and a copy of the signed certified mail return receipt for both cases, signed for on October 10th, 2023.
Exhibits A and B are admitted in each case.
On August 22nd, 2023, I conducted my initial inspection and observed two boats with expired tags, a Pontiac with no plate, and an inoperable pickup and an inoperable vehicle, which is a clear violation of the ordinance listed above, and junkyard conditions as part of auto parts and other debris. As of my final inspection on November 14th, there's been major progress that's been made. I have had contact with the owner. She could not be here today. She knew that it would be heard today. There's a couple minor things. The Pontiac and the boat still need to be removed or tagged. And there's a window by the front. She requested time in order to get that finished.
Is there other junk besides the window?
There's a couple things on the side,
Okay.
but it's minor.
What's the county's recommendation?
For case 23-731 and case 23-728, the Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 per day per violation, along with administrative costs beginning after the date you deem sufficient to abate these violations. This amount is appropriate given the severity of the violation and the respondent's actions relative to this violation, and we would also have the special master additionally find that it's the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
I'm going to grant 30 days on the junk case and 60 days on the vehicle case because I think that's going to take longer to fix. To the extent that they're not brought into compliance as ordered, a penalty of $50 per day in each.
Thank you.
Yeah.
Next case, Stevie Thornton and Eric Clifford, case number 2023-594. Code Officer Brandon Norman, page 34 of your agenda.
Brandon Norman, Citrus County Code Compliance Officer. This is for case 2023-00594, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. This is for address 3444 East Lee Drive in Inverness, Florida, 34453. Property owner listed as Stevie Thornton and Eric Clifford. I have good service via signed certified mail return receipt. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A will be photos taken during the initial inspection on August 3rd, 2023, the corrective action inspection done on September 12th, 2023, and the final inspection done yesterday, November 14th, 2023. Exhibit B will be a copy of the notice of violation, a copy of the notice of hearing, a copy of the pre-hearing order, and a copy of the signed certified mail return receipt.
Thank you. Exhibits A and B are evidence.
On August 3rd, 2023, an initial inspection was conducted of the property for junk and debris. The property was found to be in violation. The property remained in violation at my notice of violation corrective action inspection done September 12th, 2023, as well as my pre-hearing inspection done yesterday, November 14th, 2023. I have had contact with the property owners on this and another case that they abated. They are aware of the violation and how to bring it into compliance. It's kind of hard to see from the last photo, but there's a bunch of trash and debris that's thrown in the backyard. I tried taking several photos, but couldn't quite capture it, so.
Okay, what's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $100 per day along with the administrative cost to begin after the date that you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. We would also ask that the special master find it as the respondent's responsibility to contact the Code Compliance Division once the violation has been abated in order to allow for reinspection.
Property's in violation. I'll grant 30 days from today to abate it, after which, if it is not abated, a $100 per day fine will be assessed.
Thank you.
Next case, Lawrence Wong In Kwong, 2023-805, Code Officer Amy Becker, page 35 of your agenda.
Amy Becker, Citrus County Code Compliance Officer. This is case number 23-805, excessive growth and accumulation of vegetation, a violation of the Citrus County Code of Ordinances, Chapter 20, Article 6, Section 20-61. The address is 36 South Adams Street, Beverly Hills, Florida. The property owner is Lawrence Wong In Wong. I have good service via posting of the property as well as the Lecanto Government Building. I would like to authenticate the following documents and request that they be admitted to evidence. Photos taken during my initial inspection on September 7th, 2023. Photos taken on October 25th, 2023, showing the posting of the property, and photos taken on my final inspection November 14th, 2023. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing and pre-hearing order, and a copy of the posting affidavit.
Oh, you're right. Wow. Yeah, it's time. Let's last one, fast one, guys. Let's, thank you. Do y'all have a cafeteria? Oh, it's a lounge.
Yes, it's a little kitchen.
All
On
right.
September 7th,
A and B are evidence.
I
Sorry.
apologize.
That's okay.
On October 7th, 2023, I conducted my initial inspection for excessive growth and accumulation of vegetation and observed grass in 18 inches of the property, which is a clear violation of the ordinance listed above. As of my final inspection on November 14th, 2023, the property remains in violation. I haven't had contact with the owner, and I have not had contact with the tenant.
What's your recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 per day, along with administrative costs beginning after the date you deem sufficient to abate this violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. And we would also ask that the special master additionally find that it's the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
Yeah.
Take a breath.
Property is in violation. I'll grant 14 days to abate it, after which time a fine of $50 per day would accrue if it's not abated.
Thank you.
Thank you for getting closer. You're ready to go.
Next case, Penny Lee Zapf, case number 2023-316, Code Officer Brandon Norman, page 36 of your agenda.
Brandon Norman, Citrus County Code Compliance Officer. This is for case 2023-00316, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. The address is 6165 East Tudor Street in Inverness, Florida, 34452. Property owner listed as Penny Lee Zapf. I have good service via posting at the property in the Lecanto Government Building, and I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A will be photos taken during the initial inspection on July 20th, 2023. The corrective action inspection I did on September 5th, 2023, and the final inspection on yesterday's date of November 14th, 2023. Exhibit B will be a copy of the notice of violation, a copy of the notice of hearing, a copy of the pre-hearing order, a copy of the posting affidavit that I completed, as well as photos of the posted notice of hearing at the property.
Thank you. Exhibits A and B are evidence.
On July 20th, 2023, an initial inspection was conducted of the property for junk and debris. The property was found to be in violation, and it remained in violation of my notice of violation corrective action inspection done September 5th, 2023, as well as my pre-hearing inspection done yesterday, November 14th, 2023. I have made contact with the property owner's son, as who they identify themselves as. They are aware of the violation and how to come into compliance.
Yeah, it looks like they're close,
Mhm.
unless I'm mistaken.
Yeah, he told me he was going to have the trailer of trash pulled out.
Yeah.
It wasn't done yesterday. So.
Okay. What's the county recommendation?
Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $100 per day for the trash and for the quantity of the trash, along with the administrative costs begin after the date that you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. We would also ask that the special master finance respondent's responsibility to contact the Code Compliance Division once the violation has been abated in order to allow for reinspection.
I adopt the county's proposed findings of fact. I'll grant 14 days to abate the violation. If it's not abated in that time, a fine of $100 per day will be assessed.
Thank you.
I believe that was the last case.
Yes, sir.
Is there anything else the county wants to take up at this time? Okay. The time is 1 o'clock. This hearing is adjourned.